Morning, it's 10 o'clock. Mr. Green, do you need a few more minutes or are you ready? You ready? Okay, well. Okay, good morning, everybody. The inquiry is open. I'm Paul Dignan, I'm the inspector appointed the Secretary of State to conduct this inquiry and to determine appeals made under Section 174 of the Town and Country Planning Act 1990 against the issuing of 3 enforcement notices by Basildon Council, and under Section 78 against the refusal of planning permission and the failure of the council to determine applications to vary a planning permission. That's applications made under Section 73 of the Act. And the appeals relate to land south of Newlands Road, Wickford, Essex. There are rather a lot of appeals. There are rather a lot of grounds knocking around. There's a lot of appellants, and not all are represented today. So I think half the morning will be spent sorting things out. But yeah, bear with me. I'm going to have to ask a few questions of people because I have a vast amount of documents, and so some may have superseded others. I can't really tell at this stage. So anyway, it'll all be sorted out. So first of all, could I ask if anybody's mobile phone switched on, if they could switch it off or switch it to silent, please? There aren't any fire alarms, fire drills today. So if the fire alarm goes off, if there's a fire, so, oh, well, there may not be a fire, but there could be toast burning or something. But we have to leave the room, and we're going to be led out by the council. They're going to help us to assemble in the market area if you get lost. Hopefully everybody knows where the market area is, but I assume you go out past the courtyard, is it? Yeah, okay. Well, we'll follow somebody. And I haven't checked where the loos and things are. Can you just somebody, for the sake of everybody, where are they? Okay, so toilets are straight out, doors opposite. Okay, quickly run through the appeals notices. So we've had a pre-inquiry meeting. So there have been some ground rules established already. And we've decided, in our wisdom, to call the notices. Notice 1 is the enforcement notice that whose matter alleged to constitute a breach of planning control is without planning permission, the breach of condition 2 of planning permission granted on appeal on the 9th of November 2010 pursuant to reference. I won't read it out. So that's the original planning permission for the site, which was granted on appeal in 2010. And that notice covers the whole site. Okay. Then we've got 2 subsequent notices which concern notice 2. We're calling the laying of hardcore and hard standing and associated material on the land forming an area of hard standing. That covers plot 3 and the access to it. We have got various maps showing the plots. I haven't got one in front of me at the moment, but I can pull it up. Sorry, I should say I'm working mostly on the computer. So I've got scraps of paper around the place, bits and bobs on it, but if there's any question about what plot is what, we can resolve it. But plot 3 is, I think it's the plot that Mr. Green's clients live on. Yeah, okay. And notice 3 is without planning permission, operational development consisting of the laying of hardcore construction waste and associated material onto the land, forming an area of hard standing and access routes, and the erection of buildings and the erection of lampposts. And that covers all except plots 1 and 3. Plot 1 being the original plot, which is the paddocks, I think. Is that what it's called? Yeah. Is that, are you, Ms. Richardson? Yeah, okay. Okay. Morning. The notice 1 appeals, if you can remember back to what that one was, that's the breach of condition. That's proceeding on grounds A, which is that planning permission should be granted. D, that it's too late to take enforcement action. F, that the requirements exceed what is necessary to remedy the breach. I take it that that's the angle we're taking today, and not, well, sorry, it can be the requirements can seek to remedy the breach or the harm to amenity, but they're separate, and we're, as far as I can see, talking about remedying the breach. Okay, so it's a technical point for most people, but the advocates will pick it up. And there's ground G. Ground G is that the time for compliance isn't long enough, and a period of 2 years is sought in this case. I think, is it 4 months is the compliance for each of them, without reaching for the notices? Anyway, 2 years is sought. Is that correct, Mr. Green? Still? Yeah. Enforcement notice 1 is also appealed separately on the grounds B, C, and D, and that's the Anderson, the Jamie and Peggy Anderson appeals, which is what Ms. Wilkinson is here today for. That's appealed on ground B, that the breach has not occurred. Ground C, that there's not been a breach of planning permission, or that the breach doesn't require planning permission. Well, it's not been a breach of planning control, I should say. And ground D, that it's too late to take enforcement action. I'll go through them all in a few minutes, because there's a lot of overlap between grounds here. Notice 2 is appealed on A, F, and G. Recall A is that planning permission should be granted, F is the requirements, and G is the period for compliance. 2 years is sought for that as well, as I understand. And notice 3 is pleaded on grounds A, D, F, and G. And is anyone here for notice 3, which is the one that concerns all except, that's the operational development on all except plots 1 and 3. Mr. Green originally made the thanks. You originally made that appeal, didn't you?
Well, yeah. We were instructed to make more appeals than we now represent.
Yeah, I understand. I know that. Anyway, notice 3, A again, that planning permission should be granted. And there's a D, F, and G on that. And the D, I'll have to find out at some stage exactly. The D isn't, because you haven't gone through to the whole proof stage on these appeals. Yeah.
On one of
I'm just
big notices we have,
yeah.
The ops notice we have.
Yeah, notice 3 I'm talking about, the ops notice for all of them except.
There's a separate ops notice for my client.
Yep. So yeah, just you're going to have to help me on that and tell me what the D is specific. I know that you made the appeal. I need to find out from somebody. You're going to have to. Well, I'll press you on it. That's all. Yeah. No, I know you're not. You'll have to try and assist me on that. I need to know the specifics of the buildings and the hard standing that you were appealing ground D on the basis of at that time. So if you can just help me on that one, if there's nobody else to. Okay. Planning appeals that are referred to the Section 73A applications. There's 3 applications, I think, and they're all applications the same nature. They're applications to vary the original permission, vary conditions 2 and 3 of the original, and that's to allow further because the original planning permission, I'm sure everybody should know at this stage, allows 2 caravans to be stationed on the site, and Section 73 applications effectively seek additional caravans on 3 plots, 3 separate plots. They seek to allow to vary the commercial or the parking condition to allow, I think, a parking of commercial vehicles on the site. You can't remember?
That's an interesting point. Of course, we're representing on one of the Section 73 appeals.
I can.
Obviously, we submitted the other 2 applications and appealed them, but
yeah, I was looking at one of your early attempts at a statement of common ground earlier. Okay, and you want to remove conditions 5 and 6, which are the layout conditions, layout and landscaping, I think. And Section 78 refusal is simple one for the use of land for the stationing of caravans for residential purposes, and that's plot 3, I think. Okay. If you take appearances, I'll start with you, Mr. Green, because you've already been name checked quite a few times. I should say I have done quite a few appeals with Mr. Green, so which is why I know him so well. But if you could introduce yourself and your witnesses, please.
Good morning, sir. I'm Matthew Green at Green Planning Studio. I'll be double heading, so doing advocacy and witness work. And I have with me the lay witness, Steve Anderson.
Thank you. For the council.
Good morning, sir. My name is Alex Goodman of myself. I will be calling first Ellis on planning merits, so Cummings on enforcement matters, Silver Brunner on greenbelt matters, Steve Jarman on the needs for gypsies and travellers, side of the assistant planning.
Sorry, Ms. Wilkinson. Great. Yeah, I've had, everyone is aware of that. I think you've all had your documents. No? Ms. Wilkinson, so you've got an opening statement and statement of common ground, which we'll discuss in a minute. Did you want to give evidence as well? You said you're here as a witness. I mean, essentially, if you give an opening statement. Yeah. But do you wish to give evidence is what I was going to say. Yes. Okay.
Been asked, sir, if everyone could just turn on their microphones when they speak. Yours is on, but mine wasn't. So
yeah, sorry about that. I'm still getting through the preliminaries here. So yeah, we have to use microphones because the inquiry is being live streamed on YouTube by the council. So if you don't use a microphone, it won't show up. I've had mine on the whole time. How many can you have on at a time? You can only have one on at a time. Okay, so bear in mind that when you fit. Everybody hear that? Good. Okay, well, I'll keep mine on for now because I'm still talking. There are, well, anyone else who wishes to speak for any of the appellants today? No. I gather there are, oh, I'm expecting members of the public here to speak. Yeah, good. Could you let yourselves be known? I'll go from left to right. So you had your hand up? Yeah. Ray.
Good morning. My name is Ray White. I reside at Arundel, the Chase, Cranfield Park, off of Cranfield Park Road, Wickford, Essex. I'm here to represent my family and the residents of the Chase, and also members of the community that I've spoken to with regards to this matter being discussed here today.
Thank you, Mr. White. We'll make arrangements for you to speak at some stage today, hopefully, but you need to turn your microphone off.
Good morning, sir.
26.
Good morning. My name's Leanne Tarrant. I reside at Sunnydale, the Chase, and I have an impact statement for you.
Leanne, is that with Leanne?
Leanne.
Okay, thanks.
Good morning, my name is Kevin Andrews. I live at Cuckoo's Nest, the Chase, here to represent my wife and I, and as acting chairman of the residents group to represent all of the Chase residents. Kevin Andrews.
Thank you. Anyone else who wishes to speak? Did you say you wish to speak today? Yeah. Or, well, sorry? I didn't catch.
Please don't.
Interest in the appeals? Okay.
There we go.
So there's a microphone on seat 39. If you could switch that off.
I think that's me.
I thought you seat 28 just appeared.
Okay.
I've got a fantastic display here, but
Yeah, it's on here.
Okay. I understand there's to be other Stokes have prepared witness statements and also Taylor's. I'm Stuart Crothers.
yeah.
There's at least 6 of the pitches which have been occupied since prior to the owned.
I think we need to early on ensure that Mr. Crothers doesn't start representing other people's interests.
No, I'm not representing anyone's interest. I'm just telling.
Well, I think he's going to make some submissions on behalf of some clients.
No, all I'm doing is I'm making the inspector aware that there are at least 6 of the pitches that weren't served with enforcement notices, and I understand that they're seeking to make representations today. Miss Stokes is one of those. We'll see. There isn't a ground E on any of the appeals. That's fine. Okay. You indicated last week that there would be some documents being provided today. Is that, you said there'd be statements coming? Okay.
Oh, sorry, yes, I have indeed. I have them here.
Right, okay.
Would Ms Stokes like to arrange for those to be copied now?
I'm just about to. The Stokes.
Yes,
You have a statement, or you have some kind of representation.
yes, I have,
that you want.
yeah, I have a statement here, yes.
Do you have copies of them?
Yes, I do.
How many copies do you have?
4 of them.
Okay. Could I ask you to? So it's well. Could I ask you to pass? Keep a copy for yourself.
No, it's only got one of each.
All right. Okay. Could I ask them that they be copied by the council?
Yes,
What?
sir.
So one of each. So one from each of 4 different plots. Is it?
3 different plots.
Okay. Can we arrange them to get some copies, and then when they're returned, I'll ask Ms Stokes to explain what they are.
But
No. I'm talking about the statements.
To read, they've got they're done in the usual format.
Well, perhaps. Yeah. Well, I'd say if you can get them copied now, and it'll be a while before we get there anyway.
Should we get 6 copies?
Yeah. Well, we need one further. Is there a public documents table here anyway? Yeah. I know there's a list of documents, but yeah. I've got a list, but I haven't. I don't think I have access
After
to
you copied, if we could scan them and
yeah,
put
if you
them
could
on the
upload them
website.
to, well, don't upload them until we've seen them, please, because I don't know what's in them. Okay. I don't know who seat 39 is, but if you could switch off your microphone, please. All right, okay. The Stokes could, thanks. Okay, anybody else who wants to speak in opposition or in support of the appeals? It's not final. If somebody does decide that they need to speak at any stage, just let me know, please. But I have got the names of everybody who wants to speak at this stage. I have had a copy of the council's letter of notification. Just need to check with the council. They haven't received any further submissions. No? Good, thank you. I've got statements of common ground, but I don't think I've got a statement of common ground, so to speak. Ms Wilkinson provided one. I assume that that's not going to be agreed by the council. But it's just you provided one.
We provided one to the council.
Yeah.
The council then sent us one back,
Yeah.
incorporating the other plots as well. I'm not signing a statement of common ground, incorporating agreeing to material is if I
Yeah.
involved in my case. So we said to the council, no, we sent out back saying, work off a single one between us and the council. They refused, that they were signing one that covered everything. So I'm afraid we hit a brick wall if the council weren't prepared to work bilaterally with us.
Yes, there's no statement of common ground agreed between parties. We'll try and make some progress so that you get one before the end of the inquiry.
Thank you. I wasn't really expecting to get a completed statement of common ground, but it's always nice to have one in the end.
Couple of years, we've done probably about 90% of cases.
It's I'm not saying it's not possible. That's not. It may be a lot easier to sign a statement of common ground at the end of this inquiry than at the beginning, because certain matters might be resolved, but well, may or may not, but things will be clearer. The documents position, as I said, that there are a lot of documents. Some possibly redundant now because they've been submitted by Green Planning Studios for clients they no longer represent. But for the purposes of this inquiry, I take it we're dealing essentially with the most recent proofs submitted. You've all seen each other's proofs, Mr. Green?
So,
Yep. I've got, well, let's just quickly discuss.
If we knew which the date of the latest proofs were, just so I'm not missing something, that's the, you never know you're missing something if you don't know it's there.
Anyway, let me see.
Some things were updated, others weren't.
So for the council, the proofs, the recent proofs I've got in are Ms. Ellis and Mr. Cummings. I've got an ORS statement, which is effectively the proof of Mr. Jarman. Although I understand Mr. Jarman is appearing tomorrow to.
Yes, sir.
For round table.
Yes, I think at the CMC there was a Wednesday morning session scheduled for that, so he's travelling.
Yeah, well, I sent a note out in the meantime saying we'd try and accommodate that on Wednesday morning. So should I have a proof for Ms. Gruner?
Yes, you should.
Should I? Was that contained in something else?
I don't.
I'm just trying to make sure, was it attached to something or no?
Mine's dated.
I'll send emails to all the agents.
But why don't you say that?
All proofs were sent via the Planning Inspector portal, and also I sent emails to both agents. At the time it was Homes and Hills, who's acting on behalf of the Ansons, on the Ansons, and also I sent copies to appeals at Green Planning, and that was 4 weeks before this inquiry opened. And I did get acknowledgement back from the inspector that they've received them, and also from Homes and Hills, but nothing from Green Planning.
Any particular appeal number you sent them in with? Or for attached to?
I apologise. The system looks different because
Yeah.
the others, it doesn't have the same front. That's what
The title of the emails that were sent over, I did refer to references numbers ending 897, 381, 438 and 307. So all the case lead numbers I referred to on the emails that were sent.
Yeah, I'm looking in 438 at the moment. And, it's what's called landscape proof of evidence. Isn't it?
That's it.
Right. It comes up similar to an appendix to this Alice's. Okay.
So we don't touch
Hmm?
that's on this, we don't find that.
Yeah, I'm just finding it for myself. Yeah, got that. And we've got Ms. Wilkinson's proof as well. Mr. Green's proof and accompanying documents. I take it you've got all of them. Mr. Green's proof. Yeah.
Yes,
And
I
that
do.
that was a draft, I think, because you were unwell.
Yes.
But I take it you'll set us straight if there's anything
That was,
in it.
that was
Yeah, but I think that as I recall, there's a disclaimer early on in the.
yes, yeah.
Yeah, that's fine.
You also have the need statement.
Yes.
So if you could put separate standalone document. Cross-reference. And have the appendix, you have the draft of the statement.
Yes.
When you said proof of Ms. Wilkinson, do you mean the statement of the 8th of November 23?
The document you provided a proof.
Right.
Yeah, but I think it just came in. Did it come in yesterday or Friday?
Oh, that one. Sorry. Yes. That one I've seen.
Okay. And any other documents, as they're referred to, if they can't be found, we'll look for them. But as I say, there are a vast number of documents here. I could spend all morning reading them out. As long as everybody's content that they've seen everybody else's principal documents.
Can I just check?
Okay.
Because as I say, there have been some updated documents. If I can just check, I've got them.
Update documents, as in.
Well, there's an updated proof of evidence, but let me go through.
Okay.
If I start, I have a proof by Miss Pilgrim. I think that's been going to be spoken to by somebody else. Is that right? Miss Lyons?
Yeah.
Miss Lyons, okay. That is dated April 23. Is that the most recent?
There are updated ones. So we've got March and April 2023 from Miss Pilgrim, and we did submit a most recent one that was sent over on the 31st of October, which is Appendix C, Miss Lyons's updated.
I don't have anything. Slide.
It would have been titled Appendix C in the email that was sent to your Green GP appeals at Green Planning.
I'll tell you what I've got, and you tell me what I haven't got. I've got a document from Pilgrim dated April 23. I have the landscape proof of evidence, which is dated March 23. That's still correct. I have Mr. Jarman's September 23 update, and I had an earlier one, so I've got two, but I'm assuming that September 23 has superseded the earlier one. And from Mr. Cummings, I have a March 23.
Great.
Then I have a March 23 document, which I don't believe I have a complete set of appendices. Appendix was number 5 or something, which we did email about. Is March the most recent one? That is, Mr. Cummings hasn't changed. But
No, so March, Cummings and. Cummings, that was
got that, because that's, I've seen something with appendix written on top of. I don't have that to hand. What I was referring to the appendix for that scale. That's something called an appendix. Oh, my apologies, if I had to. So appendix to proof of evidence. That is the update. It is when it's no date on it. I have to get it back to the 27th of October. Yes?
Yeah, that'd be right, yeah.
But that's to be read in addition
In
to,
addition to-
so it's not a replacement,
No, no, no.
right? Thank you. And then I'm hoping this helps you as well. So, but I'm just trying to establish what are the live documents as far as the council are concerned. I have an appendix to Katie Ellis's. I'm presuming that doesn't have a date on it.
It would have on the front, it says October or November 2023 on the front page. No, this is not on the front page, but that sits in with my, in line with my proof. That should be read.
This is additional.
Yes,
to your proof,
yeah.
And this is actually an October document. There is
Yeah.
actually a date.
Okay.
That's additional to your.
Mm-hmm.
So the only one I appear to maybe not have is you said that there was a proof by Lions.
Yeah.
Which replaces pilgrims.
It does have additional information in there.
It's an update.
Yeah, it's an update.
Pilgrims.
I can get that printed for you if you don't have a copy. When it was sent over by email, it was Appendix C, so someone may have bundled it together as an Appendix C at the end of. Yeah.
Yes, it says Appendix C.
Christine Lyons.
It doesn't say Christine Lyons, it still says, oh, that's what does on the inside. The
Yeah.
front cover says pilgrims.
Oh, right, inside,
And
yeah.
then Christine Lyons. appears
Yeah,
on the
that's
first
it.
word, right, so. What are we doing as well?
We're missing Mr. Cummings' October statement because the rest of them aren't really very relevant to us.
Okay, well, I anticipate lots of struggling around documents as we go along, so just yeah, but bear in mind that I've got them all on under a number of different appeal file references. But yeah, whenever there's a document, we'll track it down. In terms of other documents, I've been handed what are called witness statements here. I take it, have I got them all? Mr. Gomez, yeah, okay. Could I ask you to pass them around? I'll keep one of each. Mr. Green will want one. Mr. Goodman will want one. And then there should be one available for the public.
Mr. Green.
Yeah, if you want to put a public one just there in the end, we'll sort out location later. One for Mr. Green, one for Mr. Goodman. The first one is Mary Taylor. Oh, sorry. Okay. I didn't realize you didn't have copies of these. Could you give that to Ms. Wilkinson for now? Sorry, yeah, they're in. Sorry, I've done it wrong. Could you collect them up again? They were already collated. I thought they were in separate. Okay, so we've got Kathleen Stokes, Mary Taylor, Patrick Stokes, and John Stokes is what we should have for a full set. If you can you, that should be a full set. Can you give that to Mr. Green and take back the one that he's got there? Yeah, yeah. You should have a full set. If you bring back the other ones to me, and I'll give you full sets to hand out. My mistake. That's a full set, and that's a full set. Yes, I'm going to do that. I'm just trying to get the documents first. John, Kathleen, Patrick, Larry, full set. Ms. Wilkinson, what have you got there? Have you got a full set? Okay. Yeah. Okay.
Sorry, I have 4.
Yeah, I've got 4. Mr. Goodman, you've got?
Yes, sir.
4?
Yes, sir.
Good. And there are 2 spare sets here, which we'll make available later on. Yeah, so I do keep a document list, so that'll be first 4 documents I've got. Well, I've got John Stokes is D1, Kathleen Stokes 2, Mary Taylor. John Stokes is 1.
Yeah,
Kathleen Stokes is 2.
Yeah.
Mary Taylor is 3. And Patrick Stokes is 4. Okay.
So we've also been handed this plan by the council.
I think that's just for reference.
Okay.
No, it's just a blow up of, you've had this already, haven't you?
It's in the, oh, yes, it's in the, yeah.
Yeah. I think it might be, is it in Mr. Cummings? It's in one of them.
Yeah, it was in a smaller version.
Yeah, well, say 4. This is just for the purpose of the inquiry. Okay, quickly go on to the procedure. We'll be following the August 2000 inquiry rules. You don't need to know what they are, but roughly it runs like this. At the end of this opening, I'll discuss with the parties the need, if any, to correct the notices or vary the notices. There are some grounds which normally involve disputes on matters of fact, for which I would normally expect all evidence to be taken on oath or affirmation. Is there dispute on any matters of fact? Even I realise that there are Ground D appeals here, but I'm not sure what facts are in dispute.
Yes, there's a continuity of use appeal by Mr. Levi Anderson, which will turn on proving continuity of use.
Okay, so is that other facts you'll be disputing?
Well, that's an example of the potential facts.
It's not continuity of use, it's continuity of the location, it's a breach of condition.
Yeah.
So it's not actually about what the construction is used for. That's not what the conditions were. So, but yes, there is a factual dispute, and it may be that brands will say something about it. That's the difficulty.
Okay.
I would imagine that the council will have their comment on it, and that will probably need to be under as well. And it's possible that the
I realise there's a lot of knowledge of the site and so on. It's yeah, I hadn't actually come across a dispute of facts anywhere, but it's fine. I mean, I will just put everybody under oath and deal with that way.
Yes, sir.
Yeah. There are some facts which obviously might be disputed, which relate to Mr. Cummings' evidence, I think, which is partly about incidents that may or may not have occurred on the site. Just, I'm not sure how pertinent they are to the appeals. Yeah, thanks, Mr. Green. Unless you intend running a fear of crime point, which I don't think I've seen up to now.
I mean, the amenity issues only come in under the aegis of other harm for the question of very special circumstances balancing in Greenbelt. So no doubt those matters will be raised by neighbours in particular. They're not a strong feature of the council's case.
Or they're not. And the idea that Mr. Cummings is just going to throw
Anyway, I've raised it. Thanks, Mr. Green. Yeah, I understand that the neighbours may have a different case to put. Okay. Anyway, the point is that we will hear evidence under oath or affirmation. I say I don't mind doing it. It slows things down. But if there's any need, then that's what we're doing. Okay. Before we hear any evidence, there'll be an opportunity to make brief opening statements. Both council and the Mr. Green's appellant case will be, and Ms. Wilkinson has also submitted an open. You've submitted one already, haven't you? Yeah. Have you had copies of that?
We'll get some made, so.
Yeah, thank you. Being an enforcement case, it's normal for the appellants to present their case first by calling witnesses to give evidence in chief. I'll take it that's how you've anticipated matters.
Yes, sir.
Yep. The council will have an opportunity to cross-examine. I'll probably have some questions, and I may take questions from interested persons. That's if somebody wants to ask a question of a witness, then pass it by me first, please. And after that, there'll be an opportunity for re-examination if necessary. And I'll deal with the council's case and council's case in the same way, but bear in mind that there are different appellants represented. No, just briefly running through, I should say in the, what we call the legal grounds, B, C and D, there are, the burden of proof is on the appellant to make the case, and the test of the evidence is the balance of probabilities. Now, I've been trying to figure out Grand D. So Mr. Green's Grand D is essentially that the planning permission was never implemented. That's your main Grand D, isn't it? Yeah.
No.
Okay.
Has,
Okay.
Issue of a
Yep.
another carrot.
So you're happy that the permission was implemented?
Just bear with me.
There's a point to this.
I know.
I mean, it's an important point. And he does say that
Yep.
in his proof of evidence. So if it's not the case, it's
Something we looked at.
Yeah. I know what your case is on it. I'll explain one of the reasons. Well, one of the things I had in my mind with regards Miss Wilkinson's appeals, which are the plot one appeals, let's call them. Because I understand your position, but you are caught in a certain way by the fact that the land is the land, and it's the land which planning permission was granted is the entire site. That if there was no question that the planning permission,
Sorry, there is a question.
I know there is. Yeah, I just let me finish then. I said if there was no question that the planning permission was implemented, then I was going to suggest that it might be possible to vary, let's call it amend, notice 1 to refer to 2 conditions, that's condition 2 and condition 5.
Sorry, sir, the issue is not non-implementation. Issue is that the conditions were not approved on a development condition.
And I know,
Yes,
yeah.
so you asked whether it had been implemented. Planning permission was implemented, but then the conditions were not approved.
Yeah.
And the condition to leave for the use to cease was never complied with. So it's not that the planning permission was implemented the day it was granted.
Okay.
It was retrospective.
Doesn't work quite like that, but
No, I know there's a case, but actually that's an exceptional set.
Yeah.
The Butch case, yeah. But setting aside that, I'm not suggesting that the planning permission was not implementable.
Okay.
Whichever term you put. The issue was that there was the requirement to submit details, and for those details,
Yeah.
if they weren't approved, for
I
an
know.
appeal to be made. That wasn't, so that condition has been. And we then.
well, you say it's been breached.
Well, yeah. We're then into the very interesting.
Yeah,
As to what that condition means, as to whether the planning permission ceases or just that the use should have ceased, but the permission continued. And we say it has the effect of a temporary consent to an A1 state scenario. Other conditions then cease to have effect.
Yeah, it's a bit of a stretch, but I mean it's arguable, I'm sure.
so.
But yeah, could I just say that going back, let's assume that everything was implemented
Yep.
Would adding condition 5 to the breach and the requirements of notice 1 resolve the plot 1 position? You don't have to tell me now, it's just, the plot 1 position being the fact that nobody disputes that essentially that plot was there in existence for years in compliance with everything, and then suddenly it wasn't.
Yes, can I
Yeah.
pause on giving an answer to that point and just take instructions when there's a break on that, but it's a helpful suggestion in terms of the complicated argument about breach of condition 5 that may resolve it. My understanding is that there isn't an argument per se that the permission wasn't implemented, but there is an implication from the argument that is being made that there was a breach. There's always been a breach from prior to, well, the argument is even before permission and continuing thereafter. And so there is a factual inference from the argument that is being made that the permission was never implemented because there's never been compliance with condition 2. So that issue does arise, but it's not directly put that way by Mr. Green, but it arises as a result of the argument he is making. So I had understood that to be an issue, or certainly a problem that I would need to address.
Not from, no, not from my
So,
point of view. And the argument, sorry, no, sorry.
So you're saying, in effect, that
when Inspector Kirkbride visited the site in connection with his inquiry or whatever it was, there were more caravans.
Behind it on what is
Yeah,
known
yeah.
on this plan as plot 2.
Yeah.
Another mobile home. And it was there on the day the permission was granted. There on the site visit, I was there on the site visit. And it had remained there, and you see it in the aerial photograph. By the time that caravan is eventually removed, there are other caravans of what is known as plot 2.
Okay. Anyway, we're not in the business of resolving anything at the moment, but yeah, bear in mind the suggestion of amending notice 1. Obviously,
I don't see how it's not for, it doesn't
Yep.
exist in my client's case.
No.
So,
That's-
because number 5 has been breached for 10 years. The council don't make an issue enforcement notice against it.
Well, I think the basis of breach is number 5 is layout, isn't it? Site management plan or whatever. I don't remember which.
We submitted details.
Yeah, I know that. Yeah. So the council can respond to that one as to whether or not they assume they may have certainly have thought that they approved it, but whether it's an administrative failure or whether it's simply as you say that it should have gone.
I was actually the first to feel like anything.
Well, we don't need to speculate, but essentially, your claim is that condition was never discharged, and
Correct.
because of its structure, it ceased to have effect after.
We have the effect of them becoming essentially a temporary. Required the people to cease the building. Required the use to cease. Permission still continues because the use doesn't cease, but after 10 years that is gone.
Okay. Anything else on Grant D that we need to resolve before we move on? No, good. Let's say Grand F. Just make your cases as you go along. There's nothing particularly major in Grand F that can't be ironed out. So don't forget, just going back to the previous point about any amendments to the notice, I can make amendments to the notice. And the only test to the notices, any of the notices, the proper test is whether it would cause injustice to any of the parties, either of the parties, I should say. We're concerned about the recipients of the notice and the authors of the notice. Crunchy, I think I said it out. It's yep. Yeah, it's as I say, it's complicated because if Mr. Green is correct and condition 5 is no longer of interest to us, then it doesn't help. That's all. The effect if condition 5 had full effect and condition 2 had full effect again, which is disputed, then it would be the requirements of the notice that would effectively mean that you were the only plot that met the 2 requirements, and so would, I think.
So it's
This,
a bit more than that.
yeah.
What Avon states
Yeah, I'm just explaining.
Yeah, no, but it's important.
Yeah.
Because if condition, as we believe, condition 5 has been breached for more than 10
Yeah.
years. What Avon Estate says is that when you breach a temporary permission, from the point that you breach it, not after 10 years, all the other operative conditions, so numbers of.
Well, Avon Estate, yeah, Avon Estates is, Avon Estates is concerned specifically with a temporary condition.
Yes, and my view is this is a temporary condition.
I know it's your view, yeah. I'm just saying so.
Well, I can't see how it can be read by any other way, but this, I'm really explaining this for others in the room, sir.
Yeah.
Is that what Avon Estates, it deals with a situation where there was a caravan site where the temporary permission had been breached.
Yeah.
And in fact, in the end, it was breached for 10 years. But the important point for this is that the court said that where a condition has been breached, a temporary consent had been breached to go beyond the period. The other operative conditions, so the ones controlling who can be in the caravans, what numbers, things like that, are all unenforceable. The importance of that is if condition
I understand. Yeah.
issue enforcement notices alleging a breach of the other.
Okay. I understand your position, Mr. Green. It's
No, but I'm explaining it really rather than in the room.
okay. Yeah, it's thank you. It is a complicated position that Mr. Green has adopted.
I think Avon Estates is one of the most misunderstood.
Avon Estates is one of the most unusual, history-wise, to happen, and it's not a question that's had to be asked very often. But there is plenty of other law on temporary permissions and how they work. So I'm not sure, Ms. Wilkinson, if you're any clearer, but effectively, we're in a situation where everything has to be cleared up before everything becomes clear, if you see what I mean, which won't be at the end of this inquiry. Hopefully it'll only be when I write my decision. But so we can't resolve that one now, but I mean, that may have been a solution to your issue. But as I say, if Mr. Green is correct, then it may not need resolving in that way. Who knows? Okay, so Grand G was you can make it out again. I mean, because your Grand G for your own client was only 2 years, but for your previous clients was 2 years and 4 months. But I understand why, but I'm just
I think, sir, that it would have been 2 years, and I would take 2 years and 4 months for my current clients as well.
Yeah.
That you always need a period after the end of the occupation to do the rest of the work. Quite a long time ago that we wrote the original appeals.
Yeah, no, I understand. It's I mean, things have been going on a bit. In terms of a notice, other changes, there's only one that's absolutely required. So it's a purely technical one. It's notice 1. I think the breach comes within paragraph B of section 171A1, but it's a minor point that I can correct fairly easily. Notice 1 is the main notice we're dealing with, the change of breach planning condition. That's it.
That isn't the first notice issued in the case. That's what I'm. The first issue, notice of issue, there was an opt notice again.
Yeah.
My clients, council issued 2 notices at that time. Material came views and opt, and then through the material, it just left the opt line.
You've got the notes on the case management conference that we had in March. Yeah, so it's set out there. Notice 1 issued April 22, and that's the condition 2 notice. Notice 2 is the one you just mentioned, operation development block 3, and notice 3 is the operation development on the rest of the site.
So it's like,
I wasn't at the case management, so
Yeah, there is, have you got the note?
what's the date of notice 3? I've got the note somewhere.
Date of notice 3 is the 22nd of April 2022.
Okay, thank you. Yes.
Well, I hope that's what it is. That's what I've got on this note. I
think in the evidence there might have been lots of different names given to anything, but I'll stick with that for as far as I can. I think Mr. Cummings' evidence may have reversed 2 and 3, unfortunately, but
Yeah, there's been a bit of skipping around, but essentially that's as agreed at that conference. So that's how I'll be referring to them anyway. There's a couple of other things we agreed at the pre-inquiry meeting. Both the entire site, the subject in notice 1 was a single planning unit. Then I mentioned there might be further argument on this point. It's is there going to be further argument on that point? So we're dealing with separate planning units.
So,
No? Okay.
It's a single planning unit. I think that the dispute between the council and myself is whether or not a permission can be issued for them,
Yeah.
which is not part of the site. And that is the dispute between us. That's not about planning units, that's about overlapping permissions. Whether you can have such and such.
Yeah, I know. So the next point on that same paragraph was the validity of the Section 73A applications. Is likely to be challenged by the council, but it shouldn't have implications for any of the other appeals. So the council still, I mean, essentially, I have a view on it, but Section 73 is pretty. Courts have told us recently you can do almost anything as within the conditions side of things, but it might be that. Yeah, Mr. Goodman, you're about to say.
Yes, well, that position's maintained on Section 73A, that the way that those applications have been made as drop-ins, as it were, is complicated and we say invalid for a number of reasons. So that position's maintained. Prepared to think about that further if you've got any thoughts on it, sir.
It does have an issue, sir.
But yeah, no, the planning merits are going to be considered for the whole site.
Indeed.
And then,
Plot 1, I like
yeah,
that. And
yeah, no, it's
yeah, I just don't think other people are aware.
it's not, yeah, okay.
That actually the effect of the ground A against the enforcement notice, particularly notice 1, be argued by other people on their part.
Yeah, I think
There are still.
I'm sure there might be around. I'm sure I must have explained it through Mr. Carruthers in response to one of his questions last week, which essentially is what we've got. What's called witness statements there. I said that I don't, it may not have been copied, Mr. Carruthers wanted to.
I've seen Mr. Carruthers has forwarded some.
He forwarded
emails to
something
us,
to you, yeah, yeah.
I've not responded back, I might add, but it's has kindly sent some to us, which was what he including some of his responses. But I'm really saying that for the benefit of people in the wider group.
Yeah, okay.
But not the ground A on the council's case covers the whole site.
Yes. And the role of what's called witness statements there is I did say that the personal circumstances of the existing residents would be material considerations regardless. So that's the position we're in.
So that's what I'm
So,
backing up.
yeah, I was just trying to say that they may be aware of that because I explained it to Mr. Carruthers last week, I think, very briefly. But
The
yeah.
group are aware of that. I don't know.
yeah, so I mean, effectively, you're saying we've got a vast number of appeals, but we could have done it all with one, I think, isn't it?
So just to explain on that, the reason for the number of appeals on notice one was that if an appeal is made in one person's name and they withdraw that appeal, that could remove the right of appeal for other people if it was the only appeal. PINs only allow one person to be the legal appellant in those circumstances. So
it's not that they allow one person; they have to apply the fee somewhere.
yes.
So that's what
the
they're
ground
doing.
A
So,
fee.
yeah.
If somebody withdrew, then the ground A fee was repayable or it isn't transferable to other people. So the reason that when we
I'm sure the PINs would be flexible about that, but I understand. I'm not criticising for the number of appeals people on any particular
we
point.
to protect the circumstances of all of the people that we were representing at the start who instructed us to put appeals on their behalf. The reason for the opt only having one group was that the council would have had a ridiculous sum of money, about £150,000, if they had, or if everybody had put their opt appeal in, because the council had included everybody's opt all on the same notice, and they would have been paid multiple times over. And it's a problem with the way the council does that.
Well, anyway, let's just say that despite all of the difficulties we've discussed this morning, effectively, we're looking at whether planning permission should be granted for the site as a caravan site and the conditions that would be subject to. So if you just bear in mind that that's really what we're all here for. Let's take a break shortly. I just the number of appeals and the way that has also led to it's not the bulk number, it's because there's various notices and applications or whatever are being appealed at the same time, all concerning, fair enough, the same area vaguely. It just means that when I set out, which I'm just about to, the main issues that I'll be considering when I'm looking at the planning permission issues, which is the ground A's in the enforcement notice appeals. That'll be 3 ground A's, so that's 3 considerations, and then there's 3 separate Section 73 applications and Section 78 applications. So I'll just they will turn on the same things, but because of the way the legislation is, that they need to be framed slightly differently. I was going to say to the 2 advocates, you shouldn't need to write them down because they're already set out in the pre-inquiry meeting notes. Have you had a copy of them yet, Mr. Goodman? You've got them, okay.
I'm just asking my team to email it. In all the stuff that's been printed off, I don't seem to have your notes. So.
Okay, it's not the note. Yeah, it is the note of the case management conference.
Yes, I know.
It's been
CMC.
Yeah.
You're referring to them, and I want them on screen to.
Yeah.
It would be very helpful. It's just I can't.
You can
have them printed off.
Yeah, you can write them down
if you want, but it goes on for half a page. So.
Yeah, I should have it in a matter of a minute.
I'll run through them anyway, Mr. Green, because you'll be nothing will strike you that's out of the ordinary. So in respect of the section 73A applications and the failing to comply with conditions notice, the overarching issue is whether the condition stroke S, because we're in the section 73A applications, we're dealing with 4 conditions, whether they are necessary in the interests of the green belt and local character, which brings us to what the main issues will be, which is whether the development, variation or removal of conditions would amount to inappropriate development in the green belt. In the case of, well, I know Mr. Green's got an argument on whether breach of condition can be inappropriate development in the green belt. So that's a live issue. Then there's the effect of the development on the openness of the green belt, the effect of the development on the character and appearance of the area, the effect of the development on sensitive coastal habitats. Now, this is an issue that we've got a problem with.
Well, it shouldn't be, but I'm trying to make things difficult for everybody.
Okay. So I just anticipated the problem because, well, let's say possibly not.
Council say that you can't pay the habitats fee just for my clients can't pay the habitats fee just for themselves, but it's got to be paid for the whole site.
Well, this is the question.
Which has to be wrong.
Not necessarily. The habitats. I haven't read the council's opening, so you're ahead of me on that one. But effectively, it's the effect on sensitive habitats is something that can be mitigated by a fee. Without the fee, it won't be mitigated, which leaves me in the position of appropriate assessment. Likely.
If you're very, let's take the scenario that, and this isn't, I'm not suggesting this is now to be appealed. Let's just say you conclude that plot 1 can continue by whatever means, and that you're going to add the Andersons to that. You're going to vary the number of conditions, say, to allow across the whole site 4 statics, and 4 caravans, should say, 2 statics, 2 patrollers, whatever, to match those 2 plots. In those circumstances, the additional residential development is the Andersons, and they have paid a fee to mitigate that. So the idea that there isn't a scenario where that works, what the council appears to be saying is you can't do that. You have to grant planning permission for the whole site or not at all, presumably meaning lots of other caravans. I just don't see where they get to that. I don't see where they get to that as a starting point. It seems to me that it's just controllable by condition, and the combination of condition and the payment makes that go away.
It doesn't make it go away for everybody.
No,
it makes it go away for your clients.
Indeed, sir.
Yeah, I agree that I do have the power to grant that kind of permission that I can't remember how many plots there are there now or how many people live on the site, but it is open to me to grant permission for some and not others. It's not something I like to do. It's not something I've done before, to be quite honest, but I have been asked to do it before, and nobody's questioned the power to do it.
But in the section 73 for the Anderson, only covers them, so there's no appeal covering anybody else. So your only issue there, if you decide that can be validly done, then there really isn't an issue. The council can only argue then that section 73 is not valid. What they can't, if you decide it is valid, then the council can't argue their position vis-a-vis the mitigation, because that can only apply to the red line area of that application, which is the Andersons.
Well, I think the red line, you might need a different colour line for that particular application.
Well, okay.
But yeah, so as a section 73, the site is determined in advance.
But anyway, it does represent a genuine issue, the habitats fee issue for the site as a whole.
For the site as a whole, there's nothing to stop other people making. Can I say that really?
Yes, the problem is this, it's my position as the appropriate authority or whatever it's called, is tricky. Under habitats law, I cannot grant, except in very exceptional circumstances, permission for anything that would have an adverse effect on the integrity of a European site. And that's settled law. Mr. Crothers, you got to say something?
Yeah, I've been looking at this in some depth. It's actually a significant effect, and I think you'll find.
Don't worry, I'm.
Yeah, but what you probably aren't aware of is that Natural England aren't responsible for European sites. They actually still vest with the Secretary of State.
I'm aware of my position.
It's horrible. I'm aware of it.
But yeah.
But the point that sits there is that the SSSIs have in most cases been just at least partially destroyed, and they no longer marry with the European sites.
Yeah, well, I'm not dealing with SSSI.
Well, that's where the appropriate assessment comes, because the European site is based on the SSSI.
The SSSIs come under a different act.
Yes, but the European sites, which comes underneath the conservation and habitats regulations, are derived from the SSSIs. And the problem that
doesn't matter.
No, it does, because Natural England in most cases have managed to destroy both the species and the habitats, and the designation of the European site no longer exists.
Well, that may be a separate argument to have somewhere else, Mr. Guz. I'm simply talking here about the there is an ability to pay a fee to mitigate, and that it's acknowledged will avoid adverse effects on the integrity of the European sites. So that's the piece of law that I'm concerned with. And yeah, it does represent a genuine problem for a grant of planning permission across the whole site. And I don't quite know how to deal with it now, but I'll be getting submissions as we go along, or in the end.
Brought it to us now, I can, so otherwise.
If it's in your opening statement, I'm going to try it. I may have to break before opening, so I don't know. I'll have a look at the time in a minute. Okay. So the main issues, as I said, and then there are other material considerations which I need to take into account, which I'll go through. This the Gypsy and Traveller status of the occupants and proposed documents. I gather from Mr. Cummings' evidence that it's not going to be accepted across the site. Well, what this comes down to is whether or not I can take personal circumstances into account. Because any planning permission that would be sought or granted for the site would contain a condition that restricted occupancy to people who met a definition of gypsy and traveller, which I would have to set out in the condition itself, I think. Which brings me to the next material consideration, which is the need for gypsy and traveller sites in Basildon and the wider area, and nationally, of course, plus any implications of the Lisa Smith Court of Appeal judgment, which for anybody who isn't here, it ruled that the definition of gypsy and traveller for the purposes of national planning policy was discriminatory and therefore unlawful in a particular way, but that's the simple statement of what it found. Then there's the availability of alternative sites, whether there's been any failure of policy on the part of the council. The question of intentional unauthorised development usually crops up. I haven't read the council's opening yet, so I'm not sure if it's been cropping up here, but it may well do. Personal circumstances of the site occupiers, and that should include the best interests of any children living at the site or who are about to live at the site. If the proposals, again, trying to cover everything, if they are inappropriate development, then I need to consider whether the harm to the greenbelt by way of inappropriateness and any other harm would be clearly outweighed by other considerations so as to amount to the very special circumstances necessary to justify the development. And if they're not inappropriate, which may apply to some and not others, whether there's any conflict with the development plan, or whether any conflict with the development plan would be outweighed by other material considerations. That's presuming there is a conflict with the development plan. And I think it's largely, well, I couldn't say agreed because not everybody is here, but the outcomes of the deemed planning applications in the enforcement notice appeals concerning operational development are largely dependent on the appeals concerning the use of the land. So in other words, if planning permission isn't granted for the use of the land as a whole, then there's no real justification for a grant of planning permission for the operational development that has taken place. That's aside from any appeals on grounds D or F. Okay, after hearing the evidence, there'll be a roundtable discussion with the parties on any conditions or obligations that they favour in the event that the planning permission is granted. I think I put the word obligations in there because I wasn't sure about the mechanism for overcoming the habitats issue. I take it it's a fee. There's no need to enter into a section 106. Yeah, okay. There's no other obligations concerned then.
Yes, we're content with the payment of the fee rather than section 106.
Okay, discussing conditions is a normal procedure. It doesn't prejudice any party. It doesn't indicate any prejudging of the case. Just put that out as a warning. Now, in case it's really for members of the public who hear planning conditions being discussed at the end of a long inquiry and they've forgotten the warning at the start. It doesn't mean that there's been that planning permission is to be granted. It's just that if it was to be granted, these are the conditions that would be appropriate to impose. There's always a question of cost applications. Costs can be claimed by any parties to an appeal. I'm not inviting applications for costs, I should say. But any applications can be made, and they should be made just before the inquiry closes, after closing submissions and whatever. Okay. But pre-indications are appreciated, and exchange of reasons for costs application should always occur beforehand. Otherwise, we just have delays at the end of inquiry. What I've had to date, the council indicated at the pre-inquiry meeting that they might make applications against those who have withdrawn appeals. I'm not sure what your position on that is at the moment, Mr. Goodman.
Respectfully, I'd just like to reserve position on costs for a while.
Thank you, please. And the now withdrawn, semi-withdrawn agents for plot 1 had indicated that they would be seeking costs. That's the last I heard of them, to be honest. But do you know how they're going to do that? Are they going to turn up?
So they are going to submit a cost sheet from Michael Harmon, who was the original representative of Jamie and Peggy. And that will be submitted before the end of the inquiry.
All right, so he's still intending to do that.
Yes, correct.
And That'll be costs against the council, and he will have, hopefully, if you can advise him, he'll have sent through the basis of his costs application to them beforehand, so that they can consider their response. Okay, site visit. I'll be doing a site visit at some stage. The council wanted some pre-notification of that for their for their purposes, and I suggested Friday afternoon. Mr. Green hasn't agreed to that yet, but have you heard that? Have you heard that? You must have done.
That was in the note, yes.
It's possible my team have.
Yeah, no, the last note.
Probably partly aware. I've been doing back-to-back appeals, basically away from my office 4 days a week.
Yeah.
They do try and keep me in full loop. I can't recall correspondence regarding.
Okay.
So I am relaxed with Friday afternoon.
Yeah. You should recall some of it, because it's the same note I sent out suggesting that we might be able to complete all of the evidence this week.
Oh, I do remember that.
Yeah, I thought you did. Yeah, it's not a bad thing, but and if somehow it prevented closing submissions on Friday afternoon, I'd probably defer it to another day. So I will do a formal site visit. Provisionally, the Friday is set out for it, Friday afternoon. As I say, if there was a possibility that we would finish closing submissions by the Friday afternoon, I would probably come back another day, which I'm sure we can manage that. But
sir, from my own point of view, I would.
I know you don't want to come back.
For instance, if we complete, if we were to do closings the following Tuesday, perhaps virtually.
Yeah, no,
I don't think, this is going to be a long week. I'm not sure it was sitting up through Thursday.
Yeah.
You get a less considered set of closings.
Yeah, as I say, it's only that's the provisional time we've set out for it, and if it's movable, but I'm not going to force anybody to stay up late at night and preparing closing submissions, which we can do virtually, and the council obviously has the ability to broadcast that in some way, I take it. But yeah, it still remains possible that we'll complete this week. We've got 3.5 days.
Yes.
Anything else? I'm going to take a break before we do openings, if you're pleased. Is there anything else that anybody wants to ask about procedure or anything like that? I should say also, I have had a few requests from local representatives and locals to appear and speak at some stage, and I've indicated that the best time, that an appropriate time for them to do it would be before we hear evidence from any of the other parties. So that would be later on this morning or early afternoon, whichever.
So if we could get a clearer picture of that, that would help me at this stage, just to know who's going to speak today. So
I understand Mrs. Stokes would like to know if you'd like her to give evidence or if she can go. Her written statement and the other written statements are sufficient.
I think the witness statements are sufficient for my purposes, which is essentially to understand the personal circumstances of the occupiers of the site, if you're content with that. I'm not sure whether or not the council wanted to ask any questions of Mrs. Stokes. And I'm not sure if you've had a chance to review the statement.
I haven't. And it's up to Mrs. Stokes and whether she wants to. I've also been given a message that there's one of the neighbours who needs to go earlier. Maybe she could speak up and explain.
Yes, I've had that, but essentially we have to have openings. It's 11:41. That'll probably take us to lunchtime, I would say, or thereabouts. And then we would hear from the local residents immediately after lunch. Does that suit everybody? Yeah. And then we'll go into evidence from the main parties.
And
document.
my understanding.
And I'll discuss between yourself and Ms. Wilkinson how you wish to proceed. Yeah.
I think what we envisaged was that Mr. Jarman and Ms. Lyons would both be involved in the round table, so there may be 3 witnesses to cross-examine.
Yeah, well, I mean, I was just going to say, I assume that Ms. Lyons would be participating in the round table, especially because you seem to be challenging a lot of the supply side of things. And yeah, and if you feel the need to cross-examine her afterwards, I'm sure you can ask her to return to come to the witness stand. But
It's two.
that's
Just two there's the issue of, if we're talking about sort of factual matters on sites, that should be round table. My concern is that Miss Lyons' statement, having now looked at it, which is the additional one, strays into, if you like, council intention for the future. That is a matter that goes to our argument of failure of policy, which isn't the matter for straightforward calculation of needs. That might be something that would benefit from some cross-examination.
yeah, well, it might be a short one, but
Yeah. It could be.
So
I'm just wondering whether Ms. Lyons actually sort of the bits where she talks about individual sites are for a round table, and if that is best addressed for round table. But the bits where she's talking essentially about the council's plans, policy going forward, that would be a matter.
yeah, that shouldn't be a problem. I wouldn't have thought.
Just we just cross that bridge after the round table because we'll be in a better position. Can I just understand on the current timetable, is Mr. Green's evidence envisaged today or tomorrow afternoon?
We won't. I don't.
So you're going to just deliver it.
Yes, I've done it
as you're doing now. Yeah. Okay.
You won't have to go through his re-examination.
No, I don't think re-examination.
Okay. On Mr. Jarman's the round table tomorrow. I'm not sure if I've put it into the pre-inquiry document, but as I was expecting, generally expect a the main parties to provide me with some kind of agenda for that. If not, I'll have to
It's probably difficult for
do it
council
myself.
to do that without Steve around.
That's what that's the next point I was going to make. But anyway, if
I mean, if there was the opportunity, and I'll just say this, hopefully we're not.
yeah, I was going to say something along the same lines because
There is.
I don't think I've ever had you and Mr. Jarman
Haven't you?
at the same time.
You
But
must
I'm aware. I've had Mr. Jarman a few times, but there are other barristers and advocates that do your work, Mr. Green. So I'm just saying I'm aware that there's a lot of what's going is an ongoing war between the Gypsy and Traveller advocates and the GTAA companies about methodology and so on and so forth. But I mean,
So actually, the ongoing war, as you put it, is something that actually between our four ORS and ourselves, there has been a narrowing of the issues over time, and actually the remaining issues. If this was a GTAA done this year, as opposed to last year, we'd really be down to a couple of issues. So it isn't actually the wives that have been.
good. Yeah, I was going to say I there's only a certain number of things I need to take from that discussion. So a lot of it is not really the ongoing methodology. I'm glad you're getting closer. And,
We are
good. Nothing like agreement. Okay. If we take a break, then anybody else have any questions? It's actually, I realize that it's pressing to get all of the evidence done this week, but that's what I'm saying. Again, if needs be, the site visit can fall away if we need to finish the evidence. And
certainly would be my preference if we had to choose.
yeah, that's what I'm saying. That's why I say that the site visit is provisional. I don't want. If I come back for the site visit, obviously it's.
We'll come back in person for the. If we do the site visit next Tuesday, coming back.
Well, I don't know. Yeah, well, what days or what, but where we are, we'll decide on progress during the week. Okay. No other questions. It's 10 to 12. Take 15 minutes. Resume it at 12:05 for opening submissions, hopefully, and anything else that has cropped up or come into somebody's mind in the meantime. Okay, so adjourn then and resume it at We normally start, I assume there's no other questions arising over the break. Yeah, good. We normally take the appellant's opening statements first. I don't see Miss Wilkinson in the room. So.
Yes.
Yeah, okay.
I was talking to her.
Yep.
Help her up.
Okay, I'll wait till she gets back. There's no rush, Ms. Wilkinson. I'm just making sure you're back. Because the appellants go first on opening, I'll get Mr. Green to go before you. Okay. You do your opening there, but I'll get Mr. Green to go first. Essentially, it's one or other of you, given that he's ready to go. And is yours something I need to write down, or?
Sorry?
Is yours something I need to write down?
I'm afraid so, sir.
Okay.
I'm afraid so.
No, nice and brief then, please. Thank you. It makes no difference. I've just given Ms. Wilkinson a chance to. Well, first of all, she can settle in, but also she can hear. She probably hasn't heard an opening before, so yeah. But I mean, Ms. Wilkinson has provided a written opening in any case. Okay, Mr. Green.
So, sir, GPS and myself represent the Andersons, Mr. Levi Anderson, in 4 appeals. They are the appeal against the 2 enforcement notices issued on the 22nd of April 2022. Also, an appeal against one of the enforcement notices issued in April 2022. That is the enforcement notice that alleged a breach of condition 2. I also represent Mr. Anderson in relation to a non-determination appeal of the failure of Basildon Council to determine an application made under section 73A to vary conditions 2 and 3 and remove conditions 5 and 6 of planning permission granted on appeal decision, or the 2010 decision, I will refer to it as.
for the use of land as a residential caravan site. I also represent Mr. Anderson on an appeal made under section 78 against a refusal of a application for a material change of use of land for the stationing of caravans for residential purposes. I also represent Mr. Anderson in relation to an appeal against an earlier enforcement notice that covers just his land, and the access drive, relating to an enforcement notice against operational development. So there are 4 live appeals that I am representing a client in this appeal. So in relation to the breach of condition notice, the primary issue that we say, or the first issue that you need to determine, is this issue in relation to condition 5 of the 2010 permission. We say that to date, there is no evidence to suggest that Basildon Council discharged the documentation that had been submitted within the time frame to approve condition 5. There should have been, council should have determined it. If they didn't, there should have been an appeal made. The failure of both of those led to a situation where there was a 3-month period for the occupants of the caravan, at that time, Mr. Sharp, who was my client, to leave the site, Mr. James Sharp. He did not do so and continued in occupation, and indeed was then replaced, that they sold and were replaced by Miss Wilkinson and her partner, one of the extended Andersons, shall we say. And the effect of that is that that condition has been breached ever since the 9th of April 2012, which is the date that they would have had to, at that point, Mr. James Sharp would have had to leave the land. Relying on Avon Estates, the other operative conditions, so conditions controlling occupation, numbers, types of caravans, etc., are no longer enforceable from that date. And the effect of that is that the council cannot issue an enforcement notice against the breach of condition 2 because of the ongoing breach of condition 5.
Can I just interrupt you for a second?
Yes.
Good. Because we didn't discuss what would happen in the event of any grounds succeeding. So this is your ground. Is it a B? You don't have a B.
Cool. It's
it's just a challenge to the notice.
It's under D because it's a sort of evidential thing, sir. But I mean, its effect would be that there would be no basis for the council to be able to issue the notice. I don't know what that would be.
So the effect would be to quash the notice.
I suppose it's a sort of hidden ground C, sir, I suppose. Or B, yes, no breach of planning. Yes, there wouldn't be a breach of the condition. It would be hidden ground B. Yes, but it results from the effect of a ground D.
Yeah, I understand that. But what do you expect to happen then? The notice to be quashed.
Notice to be quashed.
Okay.
Yeah. Yes, B, hidden ground B. Yes. You sometimes get grounds that emerge because they result from the effect of another ground.
You sometimes get things hidden in ground B.
Well,
effectively, it's a challenge to the notice.
It's a challenge to the notice from just a factual legal proposition. It obviously if there was evidence produced that it had been discharged, that would fall away. Otherwise, sir, it is a matter for legal submissions, because there's no other evidence to be taken on it. If I am wrong about that, sir, then condition 2 has been breached for more than 10 years prior to the issue of the notice. In fact, it was being breached from the day that the decision was issued. And that would mean that the breach of condition 2 was unenforceable, given that there was a caravan on an extra caravan on the site from the day it was issued, would be unenforceable from the 9th of December 2020. And we know from Ocado, sir, that then it doesn't have to be, well, there has been a continuing breach thereafter, but that becomes irrelevant. Once that's been breached for 10 years, that's gone. And of course, the council issue their notice in March 22, and that, sir, is over 2 years after the point at which that breach of condition was unenforceable. That would lead to a quashing of the notice and the finding that there was no control on the number of caravans across the permission area. I won't touch, if you wish me to assist you on the ground D on the ops notice. I'm no longer representing anybody on the ops notice. I will need to review my notes, because but I will try and assist you if you require it, but I would have to do some background work on that.
Does that mean ground B as well?
No. There was a ground D raised against the ops notice. We submitted that appeal.
Just going back one step to the 10-year point.
No, that's not a hidden one. That's an absolutely straightforward. The breach of condition is unenforceable through the passage of time. It's a straightforward ground D. Yeah, there's nothing hidden about that at all. Yeah. So either success on either ground D, sir, results in the notice, the notice alleging a breach of condition to fall away. So if you're not with us on that, then we turn to ground A. And for my clients, you have 4 ground A appeals. You actually have ground A appeals, sir, covering every possible conclusion that you could reach as to the situation on the site. Let me deal with perhaps the one I should say the least about, the Section 78 appeal against the refusal of planning permission for a material change of use. It is our position, and I believe that of the council.
For the 4 ground A's, you mean I've got 4 planning applications?
Yeah, deemed planning consent.
Yeah,
so, sorry, 2 deemed planning consents and 2 full.
Yeah, so it's essentially 4 planning.
4 planning
applications.
Correct. Yeah. In relation to the appeal against the material change of use, it is our position, and I believe that of the council, that a material change of use has not occurred. The reason being is that the planning permission exists for a residential caravan site, and therefore any breach of planning control would be a breach of condition. We have left this appeal running, sir, in case you decided to disagree with both the council and ourselves. And I have had in my 18 years of this a situation where an inspector decided to disagree with all the parties. And I can't rule that out. So that remains there. But obviously, if you decided that what had taken place on this site was a material change of use, we have a planning application that would allow you to determine for that. Obviously, if so you decide that's the case, the breach of condition notice would fall away and our section 73 would fall away, and you would be determining our section 70 application, the material change of use. So a decision point for you is what is it there? My main case, however, is that it's not a material change of use of land, that the planning permission for a residential caravan site exists across the whole site by just.
Can I just return to your point? Yeah. So if unusually I was to agree with you.
Yes.
And the council, what do you expect to happen to that?
Well, it can have no effect, sir. You could determine it, but it can't be implemented. And the reason it can't be implemented goes back to Newbury, 1985, isn't it? Something like that.
Newbury's concerned with conditions, though.
No, everyone just thinks Newbury's about conditions. No.
Yeah.
Read on. Sir.
Okay.
What Newbury
says. If you don't need planning permission, you don't need planning permission. I know that.
Yes, it says basically if you've got planning permission for a use.
Yeah.
You can't implement the same use again with a new planning permission with different conditions, because you when you apply for a use, you're applying for a material change of use, and you can't have a material change of use if the use already exists and has permission. And so if you agree that the permission for a residential caravan site runs across the whole site, and that as a matter of fact no material change of use has taken place, what is the, if you like, the breach of condition notice is the correct way for the council to enforce this. Yeah,
I understand that.
In those circumstances, it doesn't really matter what you do with it. Even if you granted it, my client would not be able to implement it.
It matters to me.
I understand, but I'm just saying,
because I have to make a decision on it.
Well, you could set it as I've seen the phrase.
Take no further action on that one because it's not a valid. I am on. Yeah. No, Mr. Green doesn't mind what I do with it, but I do.
Yes.
So I want to know if he's asking me to, well, if he's inviting me to conclude that I should take no further action on that appeal because it effectively wasn't a valid application because it wasn't for development.
That would be, I think, the route to take, sir. Okay. Yes, to set it aside, to take no further action.
Okay.
Yeah. So, if the council and I are right and convince you, sir, that this is a breach of condition that's taking place, you have in front of you a section 73A application, which we say the council should have determined and you can determine, because it is perfectly legitimate to vary the conditions on part of a site. In fact, it's very common for applications under section 73 to be made to vary section 73 or 73A. And I may at times slip into just saying section 73. I mean section 73A, and of course I rely on Lawson Builders, which says that any application under section 73 is also an application under section 73A. So with section, we say it's that planning permission can be granted, or variation of conditions, should I say, not planning permission, variation of condition permission can be granted to vary the conditions on part of a site. Condition, you don't have to apply a variation of condition across a whole site. Very obvious one, so if there was a large planning permission for a retail estate and it had hours of opening across the whole site, and later one of the stores wants to apply to vary the hours of opening from the original consent. It's commonplace, actually. So for my clients, we also seek planning permission for their piece of land under the enforcement notice. And I say you can, under the enforcement notice, grant planning permission for one part of the site and not for the other, or as much as you like, sir. So it's entirely up to you what you do in terms of grants, a grant of permission in relation to the enforcement notice. That is clear cut. You have the power to do that. And it would be a bit odd, sir, if the council were right and that you somehow have the power under an enforcement notice to issue a planning permission just for the variation just for the Andersons, but you couldn't do the same but we couldn't apply for the same under the section 73. It's one of the reasons I say the section 73 A application must be valid. Otherwise, it's farcical. You have to wait for an enforcement notice for the permission to be dealt with. And I don't believe, I know Parliament gets a lot wrong, but I can't believe there was any intention to create a situation where the only way of making something lawful would be through the issue of an enforcement notice. That's perversity at its highest. But if those are the case, sir, oh, and there's an ops notice as well, sir, which that's parasitic on any of the three I've just discussed. So there's no case for the ops to remain if a use is not permitted. In simple terms, I'm not suggesting that would be the case. Basildon issue separate ops notices because they make more money that way. And that's been confirmed in earlier appeals just before the current officers get upset about that. So we say that planning permission tells you what you can do. In this case, residential caravan site. And conditions restrict. And conditions control matters less than development. Here, the development that has been permitted is a residential caravan site. That has already been permitted across the whole site. An inspector had put a condition limiting that to 2 caravans. A variation on that number of caravans is not per se development. If the council wanted to argue that it was development, it could only be development resulting from a material change of use. So section 55 is clear. The 2 things that constitute development are either a material change of use of land or operational development. We're now talking about, I'm particularly talking about the enforcement notice that only alleges a breach of condition 2. There's no ops included at all. We're just talking caravans. And in those circumstances, unless the council was to say that what had occurred on the site was a material change of use for intensification, which is not their case, then that condition must control a matter less than development. And if it is less than development, it is not development, because it isn't either of the limbs of development under section 55. And if it's not development, it cannot be inappropriate development. So in those circumstances, you are just considering it under the standard test rather than the test that is tilted against development, which is the effect of the very special circumstances test. Once we get past that thorny problem, sir, it's an appeal lining up a series of thorny problems for you. Once we get past that thorny problem, we are into the considerations as to whether planning permission should be granted to vary that condition, or in the circumstances you disagreed with the council for a material change of use. And so if it's a material change of use, it is inappropriate development. And there, sir, you have what I might say the very standard set of considerations for a Gypsy and Traveller appeal for my clients for a single pitch site. The harm, if there is harm to the green belt through inappropriateness, that with other harms to the green belt attracts substantial weight. There is, in practical terms, no other harm. And so we then advance a series of material considerations. The ones that would apply to any Gypsy or Traveller family are need, which is massive in this district. The lack of suitable, acceptable, affordable sites, an ongoing, a deep-rooted and ongoing failure of policy, and the likely location of sites in the borough, and the absence of a 5-year supply of Gypsy and Traveller sites. We say, if you're not applying the very special circumstances test, they easily overcome the, well, there's practically no harm. If you're applying the very special circumstances test, they would, in combination, clearly outweigh the combined harm, such that planning permission should be granted for a variation of condition or the material change of use in the alternative. And so, if you disagree with us, then you consider the addition of personal circumstances. My clients comfortably meet the 2012 definition of Gypsies and Travellers, would the other one as well, but there's no point referring to 2015 now. Their personal circumstances would be needed to be taken into account. You will hear more about them in due course, but they are set out in evidence already, and they include the best interests of the child. And the best interests of the child cannot, as a starting point, attract any less weight than any other matter. And as the Secretary of State has accepted in a Greenbelt case, that means substantial weight as a starting point. So we say if you are in the very special circumstances balance and you add the personal circumstances, you are clearly outweighed by some margin.
Is it just when did the Secretary of State decide that?
Dear, sir.
Dear.
The Secretary of State said accepted as a point. It's if you read the case, the counsel for the Secretary of State accepts that in a Greenbelt case, the starting point for the best interest of the child is substantial.
Oh, yeah, so starting case. Yeah.
Sorry?
Starting.
Well, yes, the starting point, because the law is
I know
the starting point for the best interest has no other factor can be given greater weight.
Yeah.
And the Secretary of State accepts that that's substantial weight.
Yeah, I thought you were coming up with a new point there.
No. It's just that nobody has advanced a reason why the best interest of the child should be reduced.
Yeah.
That's the point. So there's no case in front of you to reduce it from its starting point. And obviously, if that attracts substantial weight, that on its own balances out the weight that attracted to the Greenbelt harms. By definition, it has to balance it out because no other factor can have a greater weight. And then you've got these other factors, so including the other personal circumstances relating to the adults, etc., including health concerns, etc., which was why I say it was just very, very clearly outweigh the material considerations. If you're still not with us, sir, we say that you should consider a temporary consent. I've rather kindly to the council said that should only be 5 years. I say kindly because this council have never produced the site in living memory, the site's needed in living memory, and there's absolutely no suggestion they will in the future. But if that would be a temporary consent, and there, of course, the weight to that you put to the harms is reduced, sir, and that includes the weight that you would give to the harm to the green belt, and that, of course, is the case of more. And so, sir, we cannot conceive a situation that planning permission would not be granted. But if you did not, we have a ground F, which particularly relates to enforcement notice 1, and a typo point, or just a wording point in relation to the ops notice. And so ground G, we would seek 2 years with an additional 4 months to allow the ops to be removed, and that actually still is set out for the Andersons. So because it's 2 years, we say it's 2 years for what would be the breach of condition notice, which is remove the caravans, and then 4 months on top of that for the ops notice. And that is the case for the Andersons of plot 3. Well, when I say a typo, it's just a word. It's not a typo. It's a wording point. Yeah, we just said it should be just to change to former condition. I'm not quite sure what they mean by natural topography. That's the point. So.
You can't tell what the former condition was. So
yeah, but I don't know what the former typography was after.
You use the land around.
Oh, really? Where's that? No, I mean, where's the land around it that hasn't been subject to disturbance? That's the point, sir. Yeah. Former condition. Yeah. Which is what we suggested. Yeah.
I'm just saying it's not wrong necessarily.
Oh, sorry.
Ms. Wilkinson.
Hello, yes. So in regards to appeal 381 and 382, Jamie Reese Anderson and Peggy Anderson. I am Kirsty Wilkinson. I've lived on the site since 2014, purchased from Mr. James Sharp. Written statement to assist on caravans on plot 2 as well. And that's yes. Sorry, apologies. So just to assist the inspector that I am aware of the caravans on plot 2, the caravan, the mobile home, which has been there ever since I can remember and ever since I've occupied the land at plot 1. Yeah, and I do have planning permission for 1 static and 1 touring caravan since 2010, and then when I bought the land 2014.
So are you? So you've got opening submissions. So the plot 2 is just adding to that. Yeah, okay. And
sorry, just to assist on that matter,
yeah,
if needs be.
So where the caravan on plot 2 since when?
So ever since I've Mr. James Sharp has gone for planning permission in 2010,
Yeah.
that caravan sat there. So I think the aerial view says 2000, you can see 2006, but just to give my statement on that, it has been there as long as I can remember also, just to give support on that matter.
Okay, thank you. Did you want to go through the rest of your opening statement?
They're in writing for everyone to read, if that's okay, so. Obviously, I'm happy to answer any questions that you may have.
Then you're seeking to have the breach of condition notice 1, quashed,
Yes, correct.
or you want the plan amended effectively to remove your pitch
Yes,
from
correct.
it.
Yeah.
So I'm sure it's amending the plan is basically within my power, but we'll hear from the council basically on whether or not they consider there could be injustice to them, which is the test. But you know, I'd also have to be satisfied myself that it's difficult because the planning permission relates effectively to the whole site. So when you're dealing with the breach of condition notice, you have to refer back to the original planning permission. So, but no doubt we'll get the council's view on that. There's a question there about ensuring that the council exercise its powers competently. I won't question you on that, but you mightn't. Do you know what you're saying there?
So that's clear in the site around it.
So effectively, you're saying that you think your plot should be taken out of planning control side of things.
Yeah, I have obviously requested that through the original Michael Holmes and Hills, but it was continuously ignored.
Yeah, no, I'm just going through your opening statement to see what I need to read out. And effectively, you're still asking the council to withdraw or amend. And then if they don't, you want me to do the same.
Yes, please, sir.
Okay, thank you, Ms. Wilkinson.
Thank you.
Mr. Goodman?
Yes, so perhaps
Ms. Tarrant from the local neighbourhood, she's a school teacher and has told me she's taking the day off, and if she could get there for the afternoon, that would help her. So I wondered if she could be introduced now to ensure she can get away. That's fine.
Well, how long is your open going to be?
Well, you have a copy of it, I think. It's but it may be about half an hour.
What time are we now?
1:45.
What time do we need? Who is it?
Ms. Tarrant.
You need to be away what time? Yeah, okay. Yeah, it's a bit unusual to before we finished openings, but I can do that if yeah.
I don't.
Good. And you can either turn up at the witness. Depends on what. Are you likely to ask any questions? It'll yeah, no, it's I was going to say the problem, because you're on first of the residents, is that you may find you have to answer all the questions that nobody else does. It's just, this is my experience. I was going to say, if you're happy to come up, and I'll put you under oath, and we'll hear what you have to say. Mr. Green can decide whether he wants to ask any questions or not. Ms. Wilkinson will also be able to ask questions of you, because essentially you can be asked questions by the other side. I'm assuming that you're opposing, but yeah. So we'll just. We'll do that, and then yep.
Firstly, I'd like to give thanks for being given the opportunity to be able to speak here today. I'm incredibly nervous, and I'm not used to public speaking at all, so please forgive me if I lose my way. I've been in two minds for a long while about whether or not I should speak here today. The main reason behind this is I do not wish to put either myself or my family in any kind of vulnerable position. However, here I am. In 2020, my family made a decision to move out of the area we were living and find somewhere different, which was able to meet all of our needs. We moved to Sunnydale in March 2021. We are a family with 4 young children. Charlie is 7, Millie is 5, Ruben is 3, and Isabella is 2. My husband and I wanted to find a house in a quiet, rural location where the children could play on their bikes, where they could hear donkeys being fed and see horses. This was perhaps a selfish vision of mine, as being originally from Guernsey, I missed the rural lifestyle, and I desperately wanted it for my children as they grew up. During the initial viewing of our home now, the previous owner told us, whilst looking out of my now 3-year-old's bedroom, that in the mornings you can hear horses and donkeys being fed. We gazed onto this beautiful open field, and it just felt like home. There was an overwhelming peacefulness and tranquility looking out onto that field, which was the backdrop to the oak tree which sits directly in front of our home. We honestly could not believe how lucky we were to have found this home. It was falling apart inside and needed a lot of love, but the location was what sold us the property. When we moved into our house, spring was here, birds were everywhere. We had late night fox visits, which were frequent. There was no noise, no cars, as it's a private road. There were no people, no dogs, no traffic. It was absolutely perfect. We'd spent £500,000 on a house in a location that we absolutely adored. We're by no means rich. I'm a teacher, my husband is an estimator. We do not take money for granted. We work hard, both of us, and we were so proud of where we were able to live, especially during the first year of living there. We were riding our bikes along the road, playing catch in the front garden and hanging bird feeders from the oak tree. We began to make some precious memories as a family. My eldest son, Charlie, has high-functioning ADHD. The peacefulness and the calmness of where we now were meant that he could unwind and appreciate uninterrupted downtime when he needed it. Charlie is hypersensitive to noise and to bright lights. In February 2022, our life literally changed in a weekend. I remember standing on the driveway with my fellow residents of the Chase, with tears rolling down my face, holding my 6-month-old. We were watching the field that we moved to the house for be totally demolished. We had no idea of what was happening, and this started on a Friday night and was totally complete by the Sunday night. No one was able to come to help. Since that day,
we have had to deal with many things which I don't believe are a fair or acceptable thing for any family to have to deal with. We are friendly people, kind people, and well-educated people. My 3-year-old, Reuben, has a street lamp flooding into his bedroom all night. These are unnecessarily bright and are a total opposite to the pitch black road that we bought our house on. This often wakes him during the night and causes him to become unsettled. The noise of cars coming and going and engines constantly running also unsettle him. My children no longer play out on the road or even in the garden, as they've seen men jumping over the fence directly opposite our house with air rifles. My children are now terrified to walk outside their own house, even with an adult. My mum, who is 67, looks after my babies whilst I'm working. She will also not leave the house out of pure fear. I've mentioned noise a few times and how we wanted to be and loved being in a silent place. There are dogs barking all through the night and all through the day. They are obviously left outside and bark constantly. Please don't get me wrong, we have pet dogs and they bark to alert. These dogs are not alerting. They sound distressed and locked away, which has caused many sleepless nights for me and my children. We as residents have discussed the situation with the RSPCA, who came to assess it. The constant noise of the generators has been unbearable since the day they were fitted. On April the 9th, my birthday, I was suffering with horrific postnatal depression. It was an incredibly hard time for me and for my family. The generators were becoming deafening to me as I was up in the night feeding the babies. On April the 9th, I ended up leaving the house and speaking to the residents myself about what they could do about the noise. They came across to be very understanding and very caring, but alas, it is now more than a year which has passed and the generators still keep me awake every single night. There is also a constant smell of diesels in the morning where the generators have been going. On several occasions, my family have endured sleepless nights where my 2 older children have had to miss school the next day because of the dogs barking through the night. Saying that, the dogs barking is one thing. I should not have to be taking my children downstairs at 1 o'clock in the morning and putting on a television so that they cannot hear the sound of a man and a woman screaming at each other. I should also not have to cover up the sound of gunshots and sirens. On this particular night, there was furniture being thrown, glasses being broken, shouting of a woman and swearing, calling this woman every name under the sun. To end this, a gunshot was heard, children were screaming, and I knew a number of residents called the police. My children did not attend school the next day, as they had again been up all night, and we were all quite traumatised. My bedroom is on the front of the property. Having been used to the view from my bedroom window being a field, I will often get dressed with the blinds open. A sight for sore eyes, perhaps. Nevertheless, there are often groups of men hanging around the fence opposite my window. I'm not for 1 second making any accusatory comments. However, I do not find it okay that when we bought the property, there was a field there. And now at any point, morning, noon or night, there are groups of men standing around who can easily peer into my house. There have been several fires in the field since we lived here. During these fires, the fire brigade have been called as they seem to be out of control, lit late at night with plumes of black smoke. During several of the fires, myself and neighbours have found remains of the fire in our gardens. Only a few weeks ago, I was called home from work by my neighbour as a caravan had caught fire and there was panic that something could happen. The impact of the changes to the field on my life, and more importantly, my children's lives, has been nothing but destructive. To summarise, my children, ages 2 to 7, have been subject to sleepless nights, ADHD triggers, missing days of their education, fear of leaving their own house in case they see a man with a gun, watching flames grow higher and higher opposite their bedroom windows. These are not just one-offs. At what point, whilst all of this is happening, am I supposed to sit down with my children and let them know that all of the above are not correct ways to behave, despite the fact it continues to happen? I'm trying to raise positive, impactful members of society. They are currently growing up with this surrounding them, and that is not okay. To conclude, I would like to make it clear but I do not care who it is, why they are there, or what their wife's mum has done so awful for her to be called revolting names at 1 o'clock in the morning. If it was Prince Harry who had moved there, I would still be having the same grievances, in that we surround our children with role models and we make decisions based on how our children will be affected and benefited. And as Mr. Green rightly said in his opening statement, children, they're the most important, they carry the most weight. My decision and my choices of protecting my children, nurturing them, keeping them safe, and making memories are being totally taken away from me, especially if this is to become a legal site. I am a 34-year-old woman. I am a teacher, a musician, but above all of those things, I am a mother to 4 very young children. I beg the hearing to reject the request for this site to remain, and I absolutely support the council in their rejection of the retrospective planning application and agree wholeheartedly that this site needs to be reinstated to the green site we all fell in love with.
You?
A few questions. So if that's okay. You've mentioned some effects to your what we would call your amenity of the house, I just want to run through them. You've mentioned a street light, a bright street light. Am I right that occurred after February 2022? That in February 2022 or thereabouts, it's from then that that's taken place. Yes, you had bought when you'd bought the site, and the effect of the street light wasn't there when you bought your house in 21, I think you said, or 2020? March 21, yeah. And when you bought it, this problem wasn't there. No. And the noise that you hear from the site, when you bought your house, the problem wasn't there. That problem occurred from February 22 onwards. And the men with air rifles, that wasn't a problem before February 22. And the noise of the generators, that wasn't a problem before February 22. And the smell of the diesel, that wasn't a problem before 2022. Okay. In fact, before 2022, you were quite happy with what you could see and what was happening on that field. Okay. Your property, if I've got the right one, is about midway across the back end of the field. You're sort of mid-range. From your property, I've just measured it. It looks as like it's about 23 meters to the fence. Would that sound about right? Yeah, 22, 23 meters, something like that. And there's a largish tree directly opposite your house, looking between you and the site. A big oak tree, yeah. So presumably in winter you can see straight through the tree, and in summer more of it's hidden with the leaves. Yeah, okay. I just wanted for the inspector really to be able to, perhaps when he's walking around the site or something, to have. Yeah. When you bought the house, are you aware that plot 3, which is the Andersons, was already there?
When we bought the house, our solicitor they did the searches, and the land search came back, the local search came back saying that there was nothing in about to be built on the. We were aware of what was there.
Yeah, but it wasn't causing you a problem.
We stood the house. Had we know what was about to be built in that, we would not build that house.
Okay. I calculate it to be about 90 meters from your house to my client's plot. Again, would you think that's probably about right? Okay, but you, as you said, you would have bought the house, and just actually, it's about 170 meters to the plot 1, the part that this whole site started in 2010. And again, that was in existence when you bought the site, and that wasn't a problem to you. Okay, thank you very much.
Thank you, Mr. Green. Can you switch off? Ms. Wilkinson, did you have any questions? No?
No, sir, no
Yeah,
questions.
that's great. Thank you, Mr. Torrance. Yes, please. Yeah.
Is it possible for Mrs. Stokes to be heard as well, so that she can? That I think would probably be sensible.
Yeah.
You've got the witness statement.
Yes, I thought,
Just in case there's anything that anyone wants to ask.
yep. Yeah, no, can do.
He apparently doesn't want to speak.
That's what, yeah. I thought you had established that she. The Stokes? Yeah, okay. You can think about it, Ms. Stokes. You don't have to do it now anyway. Are you happy for me to put you on oath?
No,
You don't want to be put on oath?
No.
Okay. You want me to read? What's your reading like?
it's not very good. Not, I cannot read all right.
You want me to read out your statement for you?
Yes, please.
It's just because. I'll read it out and then we'll see if the council wants to ask any questions. The Kathleen Stokes of Blossom Hill, which is, are you aware of a plot number for
13,
13, is it? Okay.
yeah.
Thank you. So you bought Blossom Hill from Glen Harper in March 2022. Oh yeah, sorry, it is down here, pitch 13. You moved on in October 2022. Other members of your family moved on to it at the same time, so that you all moved on in October 22. You weren't aware when they purchased that the land was subject to any enforcement notice. You first became aware of that when the council identified there was an appeal against the enforcement notices due to be heard today. You're not well. You're currently unable to travel. You live alone at Blossom Hill, but you have support from your family. Prior to securing a home at Newlands Road, you were homeless. You lived mainly roadside, stopped at pitches at Oak Lane. Shortage of accommodation for gypsy and travellers in the district and the wider area, and the pitches at Oak Lane are understood to be unsafe for human habitation due to problems caused by the council exposing contaminated material in 2011. If you'd been aware of the fact that the council had issued planning enforcement notices against the land, you would have appealed the notices. And then you set out a statement of truth. Mr. Governor, did you have any questions to ask Mrs. Stokes? But she doesn't have to take evidence or no, she doesn't have to. I should explain if you were under oath, then your evidence carries greater weight in the inquiry.
I don't know what to say. I don't know what to say. How long is it going to take? I don't know what to say. I cannot answer questions. Okay, 20 seconds, that's fine.
Yeah. Did you have many questions to ask?
Not many, no.
So, Stokes, if I can put you under oath, if I'm sure you give the answers truthfully, it's just that Mr. Goodman would like answers to a couple of questions.
Yeah, but I'm not taking the oath.
Okay, do you still want to ask if Mrs. Stokes is not under oath?
I don't believe it. It's against my
Okay.
religion. Okay.
Affirmation, okay, fine. Sorry, I should have said both are affirmation. Repeat after me. It's a bit of a tongue twister. Solemnly, sincerely, and truly. Fair and firm that the evidence I should give of the truth, the whole truth, and nothing but the truth. Turn on, just button on the other one, I think. Yeah, I think it's the other one. Turn off. Mr. Goodman?
Mrs. Stokes, is it?
Yes.
Yes. I'm not going to ask many questions, so don't worry, and they're just simple questions. You said that you hadn't been aware of the planning enforcement notices. When did you become aware of them?
When I got that letter out, I received just put a signed letter or something. I wasn't aware of anything. I mean,
What date did you get the letter?
I don't even know what's in my bag now. I don't know.
Was it a week ago, 2 weeks ago, 4 weeks ago, 6 weeks ago? When did you become aware of it?
It could be like a weeks ago. I'm not too sure.
Not too sure when you got it.
Yeah, I'm not.
And have you seen there's lots of notices stapled around on the site? Have you seen
I
those?
can't read. So I wouldn't.
Have you ever discussed with anyone or asked what they might be about?
No.
So you've never had a discussion with anyone on the site about the planning issues?
No, because I can't read or write, so I wouldn't have to ask if I can't read or write.
Have you had a discussion with anybody on the site about the planning issues?
No.
So how did you find out 2 weeks ago that there was this inquiry?
Because one of my family members told me.
They told you 2 weeks ago?
Yeah, they had to come here, yes.
Okay. Thank you. Thank you very much, Mr. Stokes.
Thank you very much. That it?
Thank you.
Thank you.
Well, yes, that's, I have no question. Very much.
That's all.
I haven't
We're finished now.
I haven't had medical evidence, but yeah, I mean it's well. Sorry?
Yeah, so I don't want to see the medical evidence, otherwise it's going to get out of hand now.
I realise that, but yeah, can you at some stage give me just a summary of that, please? Would that be possible? Would you be able to help with that, Mr. Grothers? Just a half a page, essentially, putting the essentials of it. I don't think anybody's going to dispute it. Okay. It's there's no rush on it, but it's, as I say, it's the personal circumstances thing that I may need to consider at some stage. Thank you. Mr. Goodman, finally.
Yes, sir. This is the Basildon Borough Council. I'll refer to us as the council. You asked for a short opening. I've kept it medium, I would say. I'm sorry, I've tried to make it short. There's quite a lot to deal with. The appeals all concern the site to the eastern side of Newlands Road at the end of an unadopted road. The land is designated as Greenbelt in the adopted saved local plan and is the subject of a plotland designation in saved proposals map. The appeal site is a rectangular piece of land. It's about 0.78 hectares and has been divided into what we've described as 14 individual plots. Plot 1 directly accesses onto Newlands Road and is known as the Paddocks. This plot comprises a mobile home, an area of hard standing to the front for an in-out driveway, a small outbuilding and later lawn at the rear. Wall gates and timber fencing demarcate the boundary for this plot. Mrs. Wilkinson, who lives on this plot, will be presenting an appeal on behalf of Mr. and Mrs. Anderson. Plot 2, this plot is accessed by a track off Newlands Road and at the time of the enforcement notices comprised a mobile home, a timber stable building, a residential timber building and corrugated steel building. The plot is laid to soft and hard landscaping. Plot 3, this plot comprises 2 mobile homes, a stable building and an outbuilding. There's also a shed and kennels. The plot is mostly laid to hard standing with a small area of lawn. timber fencing and gates demarcate boundaries of the plot. It's occupied by Levi Anderson and family, who are represented by Mr. Green. Plots 4 to 14, so if you have that blown up plan, comprise the rest of the site, we understand are owned by the Sharp family, or certainly were when the notices were issued, and as far as we're aware continue to be. None of the appeals by any owners or occupiers of these plots have been pursued beyond the filing of appeal notices. The first enforcement notice concerns the site known as land south of Newlands Road, shown on the plan attached. It alleges the breach of planning control, which we've been over extensively this morning. In short, the breach of condition 2. But for the appeals, that would have taken effect on the 25th of May 2022. The second enforcement notice concerns the majority, but not all, of the appeal site. The area of the appeal site with which second EN is concerned is shown on the plan attached, and that concerns the operational development, which we've addressed this morning. Again, that would have taken effect in May 2022. The Secretary of State is there's then a third notice affecting the rest of the site, but not concerned with either Miss Wilkinson's or Levi Anderson's appeals. The Secretary of State is concerned with the following appeals. In Group 1, the live or most active appeal is from the Levi Anderson and family, Plot 3, and Mr. Green has set out that there are a number of appeals here. First of all, the appeal ending 897 on grounds A, D, F and G against the 22nd of April notice 2022, alleging the breach of condition 2. Mr. Levi Anderson is represented by Mr. Green. He has submitted a proof of evidence containing legal argument, factual evidence based on his own visits to the site, and opinion evidence in relation to planning matters, though I understand he doesn't claim to be an expert. In that proof of evidence, Mr. Green makes a number of complicated legal submissions as to the foundation of the appeals on all the grounds. These are largely premised on incorrect factual assumptions or else legally erroneous. Ground A, Mr. Levi Anderson is the only appellant to have pursued a case on Ground A with evidence. The determination of the Ground A appeal will need to be made in accordance with the development plan. The council have set out then the adopted Basildon District Local Plan SAVE policies and set out some of the relevant SAVE policies. Greenbelt policy BAS GB1 states the boundaries of the Greenbelt are drawn with reference to the foreseen long-term expansion of the built-up areas acceptable in the context of the stated purposes of the Greenbelt, and to the provisions specified in this plan. The boundaries are shown on the proposal map. Paragraph 3.1 of the local plan establishes the detailed Greenbelt boundaries for the foreseeable future. The alterations to Greenbelt boundaries are only made through preparation or replacement local plan. Policy BAS BE12 sets out that planning permission for new residential development and for the alteration and extension of existing dwellings will be refused if it causes material harm in any of the following ways: harm to the character of the surrounding area, including the street scene, overlooking, noise or disturbance to the occupants of neighbouring dwellings, overshadowing or overdominance, and traffic danger or congestion. Determination of this appeal will be steered by paragraphs 138 and 174 of the MPPF and Greenbelt policy that in the MPPF, particularly paragraph 147. The council also considers the written ministerial statement concerning intentional unauthorised development as relevant to consideration of the above appeals. For the council, Ms. Ellis gives evidence that the development of the site amounts to inappropriate development in the green belt. Substantial weight should be given to the harm by way of inappropriateness. In her opinion, the development causes significant harm to openness and conflicts with the purposes of including land in the green belt. The council submits there is also significant other harm set out in both the evidence of Miss Ellis and in the landscape proof of evidence of Silke Gruner. That evidence concludes the development results in substantial harm to the landscape character of the appeal site. The harm will be in conflict with policy BAS BE12 of the local plan and paragraphs 130 and 174 of the MPPF. It is relevant to have regard to the cumulative impact of the development and of the appeals, notwithstanding that the appeals are focused plot by plot. The council submits that the cumulative impact exacerbates the harm to Greenbelt. The development results in development contrary to 4 of the 5 purposes of the Greenbelt: a loss of openness, a failure to check unrestricted sprawl of built-up areas, a failure to prevent towns merging into one another, and in encroachment in the open countryside and the development of greenfield land. In taking that view, the council's witnesses echo the conclusions of the 2010 Inspector Kirkbride, who considered that in the context of development on a scale greater than he was considering, the narrow strip of green belt in which the site sits is particularly fragile and vulnerable. He considered that the modest development he was considering was inappropriate development, which failed to secure the purposes of the green belt, noting encroachment, merger and loss of openness, and caused other harm to the appearance of the area. The inspector will also need to consider other harm. The council submits that condition 2 of the 2010 permission is both reasonable and necessary for the purposes of paragraph 56 of the MPPF. At the DL 57, the inspector explained this condition was justified because control of intensity of use, including both the number and type of caravans, commercial vehicles activities, is important to limit the impact on the surrounding area. There's been no material change in circumstance, and the council submits the condition is reasonable and necessary for the same reason. In particular, if the restriction on the number of caravans in condition 2 is not maintained, there will be unacceptable impacts on the openness of the green belt and the character and appearance of the local area. Very special circumstances. The inspector will need to consider whether harm by inappropriateness and other harm is outweighed by very special circumstances. For Mr. Levi Anderson, he relies on a case around need. Mr. Anderson says he and his family are gypsies and travellers for the purposes of planning policy for travellers, and or that they seek planning permission for a site as gypsies or travellers within the definition of the PPTS. If these claims are accepted, it will be necessary to take into account PPTS. The council considers that the policies B, E and H, among others, are relevant to consideration of the above appeals. Mr. Levi Anderson's case disputes that the development is inappropriate. This argument is made at paragraph 196 of the proof of Mr. Green on the premise that there has been no development of the land. It is said that this is because a breach of condition is not development. This is another misconceived legal point. There has obviously been development on the site comprising both operational development and material change of use. The council's position is that in considering the ground A appeal, whether as an exercise of the power in section 1771A or B, it is necessary to consider whether very special circumstances have been demonstrated to permit more than 2 caravans to be situated on the appeal site. And now I refer to some of the cases we've cited in our statement of case. Mr. Levi Anderson relies on material considerations as amounting to very special circumstances. In summary, these are need, national, regional and local, lack of available, suitable, acceptable, affordable alternative sites, lack of a 5-year land supply, failure of policy, likely location of traveller sites, and if necessary, the personal circumstances of the site occupants, citing personal need, health and education. Mr. Anderson has provided a witness statement, which is in draft, and I understand still in draft, in which he says that he is 38 years old, lives on the site with his 45-year-old wife and his wife's parents in their 70s, and their 2 children who are at the time aged 13 and 17. Neither child attends school, but the 13-year-old is tutored at home twice a week. The council doesn't accept that its published Gypsy Traveller and Travelling Show People Accommodation Assessment is inaccurate or otherwise underestimates need in this area. The council does accept that it does not have a 5-year supply of Gypsy and Traveller pitches as of today's date. The council does not accept the appellant's submissions as to the consequences of this fact. The council does not accept there has been a failure of policy, and in any event, it's unclear on what basis the appellants contend that the failure of policy is a separate material consideration in the determination of the ground A appeal. On the assumption Mr. Levi Anderson establishes he and his family are gypsies or travellers, the council submits that the material considerations relied on by the appellants do not clearly outweigh the harm to the green belt and any other harm arising from the stationing of more than 2 caravans at the appeal site, such as to amount to very special circumstances. Further, and in any event, these other material considerations do not outweigh the harm to the green belt and to the character and appearance of the area identified above, such as to justify the stationing of more than 2 caravans on the appeal site. In addition, habitats issue, the council submits the ground A appeal cannot succeed since Natural England has identified that new residential development within the zone of influence is likely to have a significant effect on the features of interest of special protection areas and Ramsar sites through increased recreational pressure. The aim of the RAMS work is to secure financial contributions or other forms of on-site mitigations known as suitable alternative natural green space from developers to deliver projects that would mitigate the likely impact of development. It's understood that Mr. Levi Anderson has attempted to make a contribution designed to reflect the impact of the development of his plot, but that would not mitigate the development of the whole site, so is only relevant to his section 73A appeals, because he seeks an effect on those appeals to be to allow his plot independently of the others. Concluding on the merits of Levi Anderson's appeal, for these reasons, the council submits the appellants should not be permitted to station more than 2 caravans on the appeal site. This would be in conflict with policy BAS GB1 of the Basildon District Local Plan, the NPPF, in particular paragraphs 138 and 147 to 150, and so far it is engaged to the PPTS, in particular policy E. The council adopts the same position whether or not the caravans are stationed on a temporary or permanent basis. Ground D from Mr. Levi Anderson. In Levi Anderson's appeal, although not Ms. Wilkinson's, it is agreed, paragraph 96 of Mr. Green's proof, and again in his opening, that the entire appeal site is to be considered when assessing any breach of conditions. That also chimes with the inspector's preliminary indication in the March case management conference that the whole site would be considered as a single planning unit. The approach is clearly correct across all appeals. The first argument for Mr. Anderson, understood to be part of ground D, is premised on a factual assertion, which is not accepted, that condition 5 of the 2010 permission was not discharged. From there, it is argued, paragraph 48 of Mr. Green's proof, that from the 10th of April 2012, because condition 5 was not discharged, all the conditions fell away. There's no proper legal basis for that submission. It is then argued at paragraph 50, incongruously with the submission the conditions fell away, that the site was occupied continuously in breach of conditions since 2012, and it is said that the result is that the appeal site benefits from an unconditioned permission for residential use. The arguments repeated at paragraphs 90 to 91. The council submits it is a factually and legally erroneous argument at each step. There's then a second argument, paragraph 92 of the proof onwards, that there has been a continuous breach of condition 2 since 2010. The case will need to be explored in evidence. It's a case premised in part on Mr. Green's own evidence of visits to the site. He says that there were 2 mobile homes on site when he visited the site in 2010, and that there has been a breach of condition 2 ever since the permission was granted. We'll need to explore that further in evidence, sir, but just to add a couple of points here, pursuant to the openings and the discussion earlier. This does raise some complex questions around implementation, and further submissions will need to be made on the question of implementation of the planning permission. It also raises complicated issues arising from the drop-in applications, as we might call them, and again, some further thought and detailed submission will need to be given, in particular having regard to authorities like Hillside, as to how that drop-in section 73A permission could operate alongside the existing planning permission, A, on the hypothesis that there has always been a breach and so it may not have been implemented, or B, on the contrary hypothesis that it was implemented and or that there were breaches of conditions. There's some detail that needs to be thought through there, which I'll address in due course. Mr. Levi Anderson argues under ground F that the requirement that all caravans save 2 allowed in compliance with condition 2 be removed is unenforceable. That seems to be a variant of the arguments made by other appellants that because the land has been recently sold or leased into parcels, there's now a fait accompli, which in effect trumps planning control over the unit as a whole. There's nothing unenforceable about condition 2 of the 2010 planning permission, which was imposed by the Secretary of State after careful consideration by an inspector. Ground G, Mr. Levi Anderson proposes that the time for compliance be varied. So as in Mr. Green's proof, he proposed an extension of 80 years. That's at paragraph 355. That would be to use ground G, which allows a change in the time for compliance for a different purpose entirely, one of abrogating the enforcement notice. And that wouldn't be a proper or lawful way to determine ground G appeal. I understand today he's in fact pursuing a 2-year and 4-month extension. So maybe we can dispense with that part of his evidence. Mr. Levi Anderson's other appeals, there's 3 other appeals. Appeal number ending 896, that's the non-determination of the section 73A permission, sorry, application to vary condition 2. The appeal ending 307 against the enforcement notice for operational development on plot 3 only, and the appeal ending 289, which is appeal against the decision to refuse planning application, which was for the creation of a gypsy pitch on plot 3. He appeals pursuant to section 78 against non-determination. Although he has accepted that the whole site should be considered in relation to ground D appeals, this application then relates to only part of the appeal site, specifically the part referred to as plot 3. The section 73A, section 78 appeal seeks to achieve a drop-in permission just for Mr. Anderson's plot. Technical problem with that is the application site is not the same as that to which the 2010 permission pertains. The desired effect of the application appears to be either to create two overlapping planning permissions that conflict, or else to vary the existing permission in an impermissible way, so as to apply to a much smaller area than the 2010 permission. It would in effect either deprive most of the 2010 area of the benefit of planning permission. In this respect, Mr. Levi Anderson's appeal seems to be attempting to transfer the benefit of 2 caravans on site to him personally and specifically. Notwithstanding the council's concerns about validity of the application, if the council had determined the application, it would have refused to grant planning permission for 3 reasons. 1, I just summarise, it constitutes inappropriate development in the green belt, etc. 2, by virtue of design, layout and siting has an urbanising impact. And 3, falls within the zone of influence, raising the habitats issues. Mr. Anderson also pursues ground D appeals in relation to operational development, as do other appellants. These come down in many cases to evidence. The burden of proof is on the appellants to demonstrate by evidence which is precise and unambiguous that on the balance of probabilities, the development specified in the second EM was substantially complete more than 4 years before. See Sage and Brown. The appellant's evidence, whether considered on a cumulative or individual basis, does not demonstrate on the balance of probabilities that the development specified in the second EM was substantially complete more than 4 years before the 22nd of April. The council's own records demonstrate that to be the case as well. Accordingly, the council submits this ground should be dismissed. Second group, Ms. Wilkinson. This is plot 1, grounds B, C and D. Ms. Wilkinson is acting on behalf of Mr. J and Mrs. P Anderson of plot 1, the Paddocks, Newlands Road, Wickford. This is appeal reference ending 381 on grounds B, C and D. In short, she has lived on the site since, I understand her to say this morning, since around 2014, and has 4 children living with her. So just correct that to 2014, please. And has 4 children living with her. She is separated from Mr. Anderson, who lives not far away. It's understood Ms. Wilkinson has asked to have the assistance of Mr. Carruthers at the inquiry. The council submits that the appeal on ground B should be dismissed. The 2010 permission concerns the appeal site in its entirety. The conditions on the 2010 permission apply to the entirety of the appeal site. It's apparent that the matters stated in the first enforcement notice have occurred because on the appeal site there are more than 2 caravans and more than 1 static caravan or mobile home. Ground C is only pursued by Mr. and Mrs. Anderson, presented by Ms. Wilkinson. As to ground D, this is pursued for similar reasons stated in relation to Levi Anderson. None of Ms. Wilkinson's grounds of appeal can succeed. She has not relied on grounds A or G. Her case is essentially that she should be regarded as the original occupier of the site, with the personal benefit of the 2010 planning permission. Ms. Wilkinson's case may make sense to her from a lay perspective, and indeed the evidence of Mr. Anderson, her ex-party, prepared by the original solicitors, is framed in terms of that, to my mind, he was the beneficiary of the planning permission. However, the planning permission is a legal document to be construed objectively. It allows no more than 2 caravans on the 2010 site as a whole. It did not specify that Mrs. Wilkinson's site was distinct. It's apparent from the various conveyances that in selling off the various parcels of land, there has been the involvement of solicitors, alive to the need for covenants, and covenants have been imposed in each of the disposals, but no covenants sought to secure Mrs. Wilkinson that her site would be the only one with the benefit of the planning permission. That then leaves those apparently no longer participating. I've called them Group 3. The withdrawn appeals are the Carr, Ramsey and Parish appeals. And then we've had no evidence or communication in respect of the Sharp family, who own plots 4 to 14, Stevens, Connors, Newhouse, Isles and Pomfret. Mr. Green is no longer representing some of those appellants. He's not suggested he is doing. Since he confirmed he no longer represents Ms Newhouse, has not made it known to the council who is representing her or whether she had intended to be involved in the process. The council believes that Ms Newhouse, Mr Isles, Mr Pomfret, Mr Sharp may never have lived on the site. No further communication has been received from them since the appeal notices. The council believes that Ms Sandra Connors and Ms Charlotte Stevens have left the site and no longer live there. The council's had no communication from them since the appeal notices. The above represents the council's understanding based on communications, and its hope may give some idea of whose cases are likely to be the focus at the inquiry, but it will be appreciated there's not been a great deal of communication from the appellants. At conclusion, the council will ask the inspector to dismiss all of the appeals. I'm very grateful, sir. That's the opening for the council.
Thank you, Mr. Goodman.
Sir, there are words and if I say them now, it might assist.
Factual errors. Okay.
Errors, yes.
It might assist Mr. Goodman then if he's set straight on.
No, because it will assist you.
Well, quickly, are these dates and
just for the benefit of the inquiry.
Yeah,
my
okay.
clients, our Newhouse and P. Isles were on site. I met them on site. This is evidence there.
all right, yeah. Don't worry about that. But
This is not evidence. Paragraph 49, Mr. Anderson accused Ground D appealed in relation to operational development. No, there are no Ground D appeals in relation to Mr. Anderson in operational development, because the operational development notice for him is the original one, so covering just
yeah.
So that is an error. There is an error of understanding in 47. Say we are trying to transfer the benefit. No, we're not. That may just be deliberate mischaracterization.
Well, that's a matter of.
So
that's a separate matter.
I don't need a reply. I really don't. It doesn't assist me.
fine.
If this is to help me, I can confirm that.
Yeah, no.
it doesn't
Well,
help me.
the only thing that's helped so far is the Ground G point.
And again, I presume this was just pettiness. Paragraph 15.
Sir, it does not help me to have comments made on my.
Yeah, don't. If you think it's pettiness, then you're supposed to be correcting
This is
errors. Is it okay?
This is a correction. It is said that does not claim to be an expert report. The evidence, I am an expert witness, and this is evidence of an expert nature. That's why I say I think either Mr.
Oh well, yeah, you can go to bat on that, but
no, I'm just pointing that out. I don't know
Okay.
where that is suggested that we say it's not an expert report.
thank you, Mr. Green. We're going to break for lunch. People will be pleased to know. I was going to say in relation to all of those named appellants who aren't turning up. I did go. Well, I made a lot of effort in the last few weeks to try to ensure that there was some attempt at least to contact them. The problem is we don't have forwarding addresses and so on and so forth. But I mean, I have tried to make them aware of today's event, and I've never heard back from any of them, so unsuccessfully, I should say. But
concern with that point at the end, it's an allegation against GPS. My clients, but
which one? The expert report?
no, well, that's the point about the suggestion that some of these people, some named people may never have lived there. I can't say for so.
Yeah, I mean, you shouldn't. Thanks for setting it straight, but I mean, it might. I don't know why you would think that, but I mean, the council must have some reason for. Yes, just saying the council must have had some reason for thinking that. I don't know what it is, but you can.
I can clarify. There's no allegation against Mr. Green, so
Yeah,
that allays his concern.
25 to 2. How long do we need for lunch? I mean, 3/4 of an hour. Yeah. I haven't got the geography of Basildon down in my head yet, so I might just get lost. I won't go to a pub. Yeah, so 30, 36, 30, 40. So that'd be back at 2:25 past 2. Which would. Yeah, so I'm just trying to work out a schedule then for the afternoon, so. We're going to hear first from the residents. And then. You're not calling any witnesses other than yourself.
No, sir, no other witnesses.
You know, when it suits you to appear, I mean, it's between yourself and Mr. Green when you just.
Whatever suits everybody else, I have no
Yeah,
problem.
okay. So in all likelihood, we'll get to your witnesses, factual evidence then. Yeah. And Ms. Wilkinson will probably get done as well.
Yes, it would.
Yeah.
Probably just logically makes some sense.
Yeah. Well, you can discuss between you, yeah. And then we probably can't start your evidence.
Probably doesn't, because we're doing round table the next morning.
Yeah.
It'd be great.
Yeah, no, it's fine.
I think it's sensible to deal with need, and then then you've dealt with that, and you.
Okay, so that seems to be as much as we can do for the rest of today when we return. Okay. I won't waste any more time. Resume at, let's say, 2:25 past 2, isn't it? Is that correct? That gives us 45 minutes.
Wilkinson back.
Oh.
I'm actually something.
Bjorn, if you did.
I was.
Good afternoon, sir. I would like to thank the members of this hearing to have the opportunity to voice my opinion and speak on behalf of the members of my family, residents of the Chase, and community members that I've spoken to with regards to this matter being discussed here today, and document our vehement objection to granting or planning permission to this illegal development on this greenbelt field. I'd like to give a little back reference to what we as a family and residents of the Chase have had to endure over the last 5 years and the reasons for our objections. My parents moved to our current address over 35 years ago. The property was bought as a retirement home after moving from Dagenham. It fitted a very specific criteria. And after years of searching and planning, they moved to this one-bedroom, timber, rough cast bungalow on the Chase. It was down an unregistered gravel road covered in potholes in a semi-rural area on a little estate with no through road, surrounded by greenbelt land, which were open fields. The Chase had an ancient hedgerow running the length of the road with a few openings exposing onto the open fields beyond, truly giving it a sense of space and tranquility associated with rural life. A big change from Dagenham. The hedgerow gave a feeling of security to this little bungalow estate. It supported a spectrum of wildlife. Red-tailed woodpeckers were regularly seen in the area, and the damage to my shed is apparent. The greenbelt fields surrounding this estate only reinforced the sense of security, knowing that the development could not be made and our rural oasis was protected. I cannot emphasize enough the feeling of serenity this area brought them. In 2019, the field opposite my house, 75 foot from my front door started to be developed. Over time, hundreds of tons of hardcore and planings started to cover the field. Our concerns grew, and we were only reassured by the fact that the council confirmed that the development was illegal and that they were aware of it. Our fear that our tranquil setting was under threat and our lives adversely affected by this illegal development was taken to another level on February 2022. The noise, the bewilderment, the disbelief of what was happening, years of worrying in that moment, seeing a JCB rip through the hedge road 75 foot from my house. Can you possibly comprehend the fear? The police were called. By the time they arrived, 80% of the hedgerow was gone, exposing an area which was once a field and now resembled a lorry park. I parked my 2 vehicles in the area where the hedge once was to stop the JCB coming through to the chase, and confronted the men on the machinery, as did the other neighbours, only to be met with foul language and threats that I cannot use in this hearing. These men had decided they wanted to put a road to this site from the chase, and that is it, regardless of our objection. No consultation with residents, no planning permission, no consideration to the environment, no concern whatsoever to the consequences of their actions. It's what they wanted, it's what they were going to do, was the attitude. Although the police turned up, they were powerless to stop the disruption separating the chase and what was once a green field. They continued well past 10 p.m. on the Friday night, and by the end of the weekend, the hedgerow was gone, exposing the field, which was now covered partly in rubble. 35 years of serenity and security gone, replaced by a continuous, step-by-step illegal development. Numerous 40-ton lorries dumping hardcore, scalpings, erecting fences, generators running 24/7, which vibrate through our property. Fights on sites, screaming, shouting, stolen caravans being removed by police being attacked, stolen vehicles being removed, caravans being burnt out, unattended dogs barking for days and nights, gunshots, the list goes on, all of which have been reported and documented to the relevant authorities. I personally have been confronted by up to 8 men one evening when I dared to look over the fence to see what was happening opposite my house. An argument ensued, one by one, surrounding me. Intimidation or heated discussion? We have the right to live in our homes free from fear of illegal activities or intimidation. The stress and distress this has caused me, my 87-year-old mother that still resides at the property, and my family is unmeasurable and irreversible to this point. My mother now feels it's unsafe to leave her property in the twilight of her years. 5 years of poor sleep and stress. What is going to be the next incident? Another caravan burnt out? Another JCB through the now fence? The negative effect this site has caused in this area has been felt by the surrounding community, and it has been immense. No one wants to see another illegal development granted planning permission at the expense of local residents, wildlife, and changing the aesthetics of the area that we all come to love. The noise pollution, antisocial behaviour, and constant fear of what's next is a situation that we have to endure, and we should not have to tolerate or endure it. It's not the reason why we moved to the area. Laws and legislations were put in place to protect the greenbelt areas from developments such as this. And as a community, family member and resident, we're appealing to this committee to refuse planning applications and enforce the land be returned to the condition it was before the site blighted our lives. And there are no special circumstances that outweigh the cost to local residents, community, and wildlife. I hope I've conveyed myself enough clarity that it'll help make you the right decision by rejecting this planning application. Thank you for your time.
Thank you.
Good afternoon, Mr. White.
Good afternoon, Mr. Green.
I missed at the start of it. How did you say you'd lived there 35 years?
My parents have lived there 35 years. My mother still lives there.
Right.
I've resided at the property for the last 10 years.
10 years, right. Okay. I understand. I was just slightly confused because the 35 and then it didn't match something else. Okay. Would I be right from your description that is it Kenwood you live in?
No, Arundel.
Arundel.
Directly opposite where the hedge was ripped out.
Oh, I can see the hedge was ripped out opposite Kenwood. That's why I was asking.
No, it's right opposite mine.
Well, there was obviously two places it looks like it was ripped out.
They went further down, but they wanted to put the road in opposite my property.
From the top. Oh, I see. So yours, if I'm coming down the Chase, when I get to the first bit where the site is, you're on the other side of the road. I understand now. Okay, right. Now, you don't recall any issues prior to 2019. You said 2019. I just want to check. That's right?
That's correct.
Yeah. Okay.
Sorry, shall I hand up this plan? So just
yeah, that would, yeah. Well, I wasn't particularly. I just wanted to establish, but we certainly would help the. Yeah.
Right, you're opposite.
Opposite block 12.
Yeah. If you have that in front of you, then
the one with the toilet block.
Could be.
There you go.
The Chase is on the left-hand side on this diagram, yes,
correct.
And you're going, so you're at block 12. Okay. 2019, yes. There's an episode that actually you've just drawn attention to, which actually isn't really in front of the inspector, because there was a previous enforcement action. But in 2019, some hardcore was put down, wasn't it? And then the council made that go away.
I believe there was a road, or they started to put a road in. And
sorry, you have over there, can't.
And that was the first time that
you noticed that.
We noticed. Well, there was a 40-foot high hedgerow in front of my property.
Right.
So the gaps in the hedgerow were further down the road.
Yeah.
So we didn't have any view into the field.
In 2019, some hardcore is put down, if you like, in the general area closest to to the Chase, on the further along from your property, sort of opposite
on the east side of the field,
opposite Fernbrook, or that area there, which is that's the house at the. So after you, there is Sunnydale, then there's Kenwood, then there's Fernbrook. They're off the photograph, so I'm moving down up here.
Right.
And so Fernbrook is opposite plot 7.
Yeah, the road ran from plot 7.
Yeah, it's that bit here. It's this
Correct.
bit here. Just to be clear, I just want the inspector on. So it's that bit of road. Okay, we're talking about. But prior to that, you were living there and you didn't have any issues with what was taking place.
Well, we was unaware of what was being taken place.
Fine.
Yeah.
Now,
had I been aware, I would have had issues with
it. Right. My clients, the track to their pitch, to pitch 3 on this
pitch 3
plan, that is put down in 2017, and pitch 3 is they're occupying it by 2018. Right. So you were unaware of that taking place. Yeah. Okay. And obviously,
had I been aware of it, I would have objected to the change of use from greenbelt fields to residential use.
Right. When the original planning permission was granted in 2010, your mother and possibly father were living there then.
Mm-hmm.
Yeah, and did they get involved in objecting?
We wasn't aware of it.
So the council issue an enforcement notice on the land right up to opposite you, and you're saying your parents didn't know about it?
The enforcement issue in 2010?
Yeah, absolutely, yeah.
Not to my knowledge, no. I wasn't informed by my parents.
Well, you
And-
might not have been
and-
living there, that's correct,
No,
isn't it?
and I'm not, they never made me aware of it.
Right, okay, so you're not aware of it, that's the safest thing we can say,
Yeah,
can't we? Yeah,
yeah.
okay, you're not aware of that. Okay, thank you very much, I've no further questions.
Okay.
Thank you. Did you have any questions? No? Thank you, Mr. White. And the step.
Yes,
Would you like to swear?
I absolutely swear. Yeah.
Okay. Right, that's Kevin Andrews.
It is.
Yeah. Just repeat after me. I, Kevin Andrews,
I, Kevin Andrews,
swear by Almighty God
swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the
the
truth,
whole truth,
the whole truth,
and nothing but.
and nothing but the truth.
Thank you.
Good afternoon. It was good morning, sorry, I meant to change it. Like the other residents, I would like to thank the hearing in allowing myself to be here and for the opportunity to present this statement from my wife, Sally, and myself, plus residents of the Chase that felt they could not be present, albeit they've raised their objections in writing. The Chase is a private road that borders the land east and south of Newlands Road, Wickford. This public hearing has been called to judge on. A little bit history of Sally and I. I'm an East End boy, born in 1958, 500 yards just from the Tower of London. A little Oliver was I, but thankfully my parents moved out and we moved to Wickford when I was 17. Met my wife, and Sally and I settled, married, had 3 kids, and lived in Wickford for all of our life after we were married. In 2016, we decided we would like to move from the property we was residing in. Having found what we planned and thought would be our perfect home for the rest of our lives, current events leading us to change this plan on our in place. First, I would like to explain to the hearing the lengths Sally and I went to ensure we were making the right choice in 2016 in considering a move to the Chase. We spent 6 weeks doing research on the area, the road itself, and the greenbelt land it sat on, and also the surrounding greenbelt land. I spoke with all the residents. Fact, I did. And we even spoke to the owners of the Elms, which is a property that also borders on the east boundary to this proposed site. Our aim was to establish nothing new was being planned in 2016 for the land and that had boundaries to the property we were looking to buy. There was a plan to change, if there was a plan to change the rural setting of our potential new home we were looking at, we would not have purchased it or even moved anywhere near it. It was critical to us that we were not going to move anything near what we have now. Having not found any evidence, including local searches, to suggest a change to the very rural setting, a friend suggested I then look at the local plan. I'm fully aware that that has subsequently been pulled by Basildon Council, but the land we live on is classed as plotlands. There was never a plan for this development. That confirmed our decision that the property was fantastic for Sally and I. We, of course, became aware, as we did our research, of the appeal decision back in 2010 on the land south and east of Newland Road to allow 2 units to remain and no more. We are aware that it was on the whole plot. It was clear that those 2 units were in place at the northern end of the land when we purchased our property in 2016. In fact, they were the very furthest distance they could be from the Chase, and the then residents that we spoke to of the Chase confirmed to us during our research that those residents in place at that time on those 2 units had not caused any issues with noise, disturbances, so we did decide to agree to purchase the property. The setting it was in, it was just beautiful, well-established English hedgerow on the eastern boundary, with gaps getting bigger in the hedgerow as you went west in the direction. Those gaps and openness had just a post and wire fence separating the Chase from the land in question. The openness was clear for all to see and enjoy. The peace and quiet was amazing. In fact, every time I pulled up at my new home, like a silly old fool, I just got out the car and stood there for a few seconds to take in the quietness and just remind myself how lucky I was to live here. Local children used to play on the field. And other than the odd horse and pony, during 3 years, may well be 2.5, but I've written 3 here, we had never had any issues or diseases from that land. We believe we and other residents should be able to rely on the past appeal decision and the conditions it imposed to protect the openness of this land, to prevent what has been illegally developed against planning rules and without any care at all to us as homeowners and residents and to the Greenbelt land itself. The stress such a development has put on the infrastructure around it, let alone us as people now suffering, it's just unacceptable. We want this public hearing to know of our strongest objection to any amendment being made to the in-place condition on this land of only 2 caravans. And we want the hearing to totally reject all the planning appeals and to not overturn the refusal to allow planning approval issued by Basildon Council and to allow the enforcement notices to be enforced. It was noted just now 2017. I don't have 2017 for a road being put in. I have 2018 when I first saw development of what is plot 3. And in early 2019, because we notified the council, a retrospective planning application was submitted by the appellant Levi Anderson for approval. At that same time, we started to see fencing and then more development of the site, all in an ad hoc manner. Our objection as residents to first this and then the more recent plots is on public record. As we've signed a petition, every resident in the Chase has submitted that to this hearing. Hundreds of 20-ton lorries, and I mean hundreds because I counted them, and the council will confirm the pictures I sent them, hundreds of lorries dumping their loads to create what we now have, a field with no grass. It's just gone, it's disappeared under rubble, hardcore and planings, and a mismatch of fencing with caravans, mobile homes, toilet blocks, sheds, mobile homes, trailers, vans, rubbish piles, the list just goes on. We were encouraged by Basildon Council's stance, we had a site meeting, that the development was viewed illegal by them and against planning policy, and then enforcement notice were issued. the owners of the against the owners of the land. But in truth, absolutely no notice was taken of those notices. It just continued. Buildings, sheds, it's just endless. Our stress levels and worry went through the roof further on 25th, Friday, the 25th of February. An evening that other residents have already said, and a night that we will never forget. It was just getting dark at approximately 5 p.m. when that JCB digger started ripping out the hedgerow that formed the western boundary to the chase from the field. No warning, no conversation with us as residents. Words cannot describe the fear Sally and I felt. How vulnerable we now were with the actions of the new plot owners. We tried to discuss what was going on, but again, like other residents, I cannot repeat here the words and foul language. The F-off word was used an awful lot by people. We called the police for help, and in fairness, they did turn up, and in reasonable force. And in fact, they stayed till after midnight to protect us as residents and to ensure there was not going to be any aggravation as they saw it. Even with the presence of the police, though, the digger continued its hedgerow destruction until well after 10 p.m. And then the following morning, it ripped out the remaining sections of the hedgerow in that westerly direction, and the boundary was completely flattened. We were left totally open and exposed to a now developing field. The complete "we do not care" attitude of the individuals giving instructions to those on the equipment doing the work was just intimidating, and I was scared for my safety. And other residents expressed the same feelings to the police as well. We reported everything that was going on, and the police, I assume, have made note of what happened. As residents of the Chase, we were determined not to allow future access to our road and services within it. And we set about an immediate task by the Monday morning of installing a new post and panel fence along that western boundary. We had been advised by the police that even though they could not stop the hedgerow being removed, as the owners of a new fence, if it had been removed by the appellants or anyone, it would be classed as criminal damage by them. So the residents paid for a new hedgerow to replace the old beautiful hedge. Understanding the importance of the new fence and the protection it could deliver became the focus of the residents for the next week. It's just a shame the original hedgerow itself forming the old boundary could not have been afforded the same protection. Oak trees have been cut down within the field. They stopped at nothing to create their plots. To my knowledge, illegal connection to water, illegal connection to electric, and we believe some plots have even accessed the sewage system. We are aware that the police and the electricity board turned up to ensure that the illegal electric connection was disconnected. That came about because of the residents of the Chase. We were fearful that allowing electric to be connected to the site would justify the site. We have been made to live with constant disturbances. First came the machinery, then the lorries. You can imagine, just picture creating a hard standing over nearly 4 acres of land. It is just crazy. Then once units were in place, we have endured dogs barking night and day. The RSPC have visited. Their stance is they need to see it 3 days later, etc., etc. The fire brigade and the police have attended. We are aware of the fights on the site, and the police had to attend. The gunshots and the rubbish, and not just garden waste, being burnt with toxic fumes. To date, to my knowledge, 2 caravans have been burnt out completely. Interestingly, while the residents of the Chase called the fire brigade and stood there taking videos and were concerned, no residents of the plots were anywhere. It was just scary. The number of reported and recorded complaints about events on this site must be huge, and I hope someone has a record of that to give you. One noise complaint visited by officers and police, even the police were attacked. Their car was rammed. How can that be right? We've had lost sleep, night after night, mental stress, the worry that brings. My wife now won't even walk my dogs past the plot. She comes out of her gate and turns right for fear. How can that be allowed to happen? It's just not correct. We want this hearing to take on board the residents' experiences. They're not made up, they're factual, they've happened. We want this hearing to uphold the original appeal decision that only 2 plots, 2 caravans, if you like, should be allowed, and everything since is a complete breach. Thank you for your time.
Thank you. Happy to answer some questions from Mr. Green.
Yes, fine.
Good afternoon, Mr. Andrews.
Good afternoon.
You moved, I think, in 2016, is that
Correct.
right? Yeah, okay. Which is your property?
So I sit next to Mr. White. So if you look at the map, I am actually, you look at plot 12, I'm literally, my boundary forms on the corner of plot 12 in an easterly direction.
Right. Okay.
So if you hold the map that way, yes, there's plot 12. My boundary's here and my property sits here. I'm dead opposite.
Yeah, can you show the inspector? And
sorry. Yeah, so plot 12, I sit on this corner here, facing this parcel of land here.
And you mentioned a property called so that's just so you're Cuckoo's Nest, is that right?
Correct.
Yeah. And you mentioned a property called the Elms. You said you spoke to the Elms.
Yes, so the Elms own this parcel of land here, which forms the eastern boundary to the now development.
So they own that field.
They own that whole field. Yes.
Right. I understand now. It's all right. I couldn't. Yes. I was wondering why the Elms had a. But they own. They own
that whole field, okay. And that comes right up to my boundary.
Yes. Yeah. No, I understand now. That's clearer to me. Okay. So when you moved to the appeal, or not when you moved to your property, what was on the appeal side?
2 units.
Right. Can you describe what you think was on the appeal side?
I can show you a picture of what was there in 2016 and remained there in 2020. That's what was there.
Okay.
That's
I don't know what you're
Google,
referring.
dated 2020.
Yeah, so the Google, and that's what it was like in 2016, you're saying?
Well, yes, we're absolutely in 2016, but I took a picture in 20. Yeah.
Right.
It's from.
Do you want to repeat that?
That's the 2013 Google Earth image.
It may well be. Mine says 2020.
No, that's when you've accessed the image. Yeah, that is the 2013 Google Earth image.
Yes.
Right.
And that's what was there.
Okay.
When we moved it.
And so we can see plot 1.
You can.
Yeah, and you can see along the eastern boundary some other things. What were they?
That was continuation of plot 1 then. There wasn't a plot 2, as you call it. because there was only one plot. It was all one plot.
Right, I didn't ask that.
Yeah, okay,
Whether it was a continuation of plot one or not
Yeah,
would depend on
yes,
who owned land
yes.
and who owned what.
fine, yes.
you may
So
or
there's
may
two
not know,
mobile
you
homes
may
on
not-
the whole plot.
There's two mobile homes on the whole plot.
Correct.
And so, so on the site as a whole, two mobile homes.
Yes,
And there's throughout the time, therefore, that you've known it, there's always been two mobile homes
correct.
or more, two or more.
Or more,
Or
correct.
more. Right,
Yes.
thank you. Okay. And then you said 3 years later, there started to be issues. That's what you said in your evidence.
It's 2018, yes, we moved in 2016.
Yeah.
In 2018, we started to see developments, and in
What month
2019,
did you move in 2016?
February.
February, because you said 3 years later, maybe 2.5, to be fair to you. That
Oh,
was your
that's-
evidence.
2018,
Would
yes.
be two and
sorry, then that was an error on my part.
yeah.
I
So
I have written down here quite clearly that we moved in at 2016, it was February, and in 2018, albeit I can't tell you which month, I could if I back check all my emails, because I reported the developments going on to the council.
okay, and so you don't think anything happened prior to 2018?
Not that I noticed, no.
Okay, I'm handing up, sir. This is actually it's just most convenient because they're in a dated set. This is actually in the exhibits attached to Jamie Rees Anderson's evidence, and is appendix. It's just a set of the aerial photographs, and it's in appendix 7 to that. And if I can hand you up the 2017 photograph, and just wait before we let the inspector get to there.
I'm trying to get my bearings on, oh, okay.
There's a whole series of appendices to a witness statement of Mr. Jamie Rees Anderson.
So this picture was taken in
Can
2017?
you just wait a second until the inspector's got the picture in front of him as well. Otherwise, we'll be going off half cock. Yeah.
Would that help us?
It's dated, sir. 19th of May 22 is the signature on it.
Yeah, I just need to get a file. Everything from the.
It's exhibit JRA 2, page, because they're page numbered, they're paginated. Let me just lost the picture now. It would be page 47. Eight, 49. 50, 51, 52, 53, I think. Then the map, the photos aren't numbered. Yeah, it would be 53. It would be exhibit JRA 2, page 53.
17 megabytes.
Oh, it's the 2017 photograph, which I think is page 53, I think. You got the numbers on the right. Okay.
Can I just say, this isn't dated, that's in front of me. Just like my Google has a date. This, I'm not denying when it was taken, but it doesn't say any date on any of these photographs.
Yeah, I mean, that's
It does on the top left-hand corner.
yeah, but in the exhibit it does.
Oh, yes, in the exhibit it does, yes. I mean, I happen to have Google Earth open as well.
No,
But I do as well, so yes, but yeah, it is. The dates can be wrong, yes.
Yeah. But I can see this photograph, yeah.
So this is, on Google Earth, it says it's May 2017, I might add. This says 4/17, but anyway, April. Early, in the first half of 2017, it would appear to be. So I think if we can take it that you noticed activity in 2018.
Correct.
You didn't notice the laying out of this additional road.
No, I didn't
leading to
notice the road.
hard standing area and the fence indeed that went along the side of that.
No, if this is 2017,
Yeah, well,
genuinely, I haven't seen it, no.
Okay, and then we turn over to the next one, which is the 2018 photograph.
Yes.
The 2018 one is said to be June.
Yes.
And this is less than 2.5 years after you moved in.
Yes.
Right, and what we see there is my client's pitch fully established.
Plot 3, yes.
Plot 3 fully established.
Yes.
So that's less than 2.5 years. Yeah.
Yes.
Yeah. Okay. Right.
But it also shows, oh no, there is still a unit on plot 2, yeah.
So would it be fair to say maybe at some point after it had reached this stage is when you noticed it?
No, I noticed, and I believe I'd have to refer to my emails, as you call it, plot 3 was being developed in terms of buildings.
Right.
That's in buildings, that's when.
But they're all there and they've been there some degree of time by June
No, they're
2018.
portable buildings. They go up in a weekend. They're not been there some.
Right.
Unfortunately, I can't confirm how.
Have you been on the site? Do you know what those things are?
Yes, well, they've changed.
You've been on plot 3, have you?
No, I haven't been on plot 3,
right,
but
okay.
I've been in the field that you see in the photograph, because it was an open field then.
All right.
Okay.
And when did you go on there?
Well, between 2019 and the planning and the development that started to take place.
All right.
And my photographs that I submitted to the council of the development of the rest of the field are on record at the council.
And which of the sharks gave you permission to go onto the field?
None of them.
None of them. Right. So you would quite happily trespass on land for the purpose of taking photographs.
If you want to class it as that, I as a concerned
exactly
resident on illegal development, I took pictures of hardcore and other things being developed on a field to gain evidence.
To be fair to you, do you understand the difference between illegal and unlawful?
Anyway, Mr. Green, I'm not sure if you need to go there.
Right. No further questions. Thanks, sir.
Thank you.
Thanks.
Thank you very much.
Yes, what I would like to ask for is if we could have a short adjournment in order to explore that other matter with Ms Wilkinson in particular. And then once I've spoken to her, I can revert to you, but I haven't had a chance to speak to her yet. So
How many?
Good. 5 minutes initially, and then I'll come back to you and tell you where we're at, if that's okay. Thank you.
I've already.
You're happy to discuss with 5 minutes?
Of course, yes.
Yeah. You can be outside for it.
Yes, thank you.
Yeah, starting in 5 minutes time.
Yes, thank you. I think I should leave you in the dark for now and then come back to you once we've had a chance to discuss, if that's
So if
all
we're
right.
adjourning for the rest of the day, we're not seeing inspector till the morning.
Well,
Can I suggest we adjourn for an hour?
for now, if you're happy with that, so.
Tell the inspector in more detail about
Yes.
others,
Yeah.
if we've concluded what we think.
Yes.
Give it 4:30.
Thank you.
Yeah.
Thank you for the time, sir. What we've managed to do in the interim period is to prepare what we've called a statement of common ground between the council, for the one part, Mr. Green on behalf of the Levi Anderson, and Miss Wilkinson on behalf of Mr. and Mrs. Anderson. So a three-way statement of common ground. And what we propose is variations to three enforcement notices. In short, the effect will be that plot 1 and plot 3 are then to continue with the access as well to plot 3. But I'll explain our mechanism for getting to that, but then leaving in place enforcement over the rest of the site. So I'm hoping someone's going to run in with a printed version of this in a moment, but it will make more sense. Do you have the enforcement notices in front of you, sir? So enforcement notice 2, which I believe is the 22nd of April 2022 enforcement notice concerning the breach of condition on the 2010 permission. Yeah.
I'm calling that notice 1.
You've been calling it 1. I
think it's notice 2. Notice 2 is the type that the
yeah, sorry. So I'm using your.
Failure to comply with planning conditions.
Whichever one that's called. Thank you. In paragraph 5 of that notice, so that should be 1. That's why I called it 1. Yes. At the outset of that, we will insert the words with the exception of 1 static caravan and 1 touring caravan on plot 1. And with the exception of 2 static caravans and 1 touring caravan on plot 2, sorry, on plot 3. And then brackets as defined in the Caravan Sites and Control of Development Act 1960 and the Caravan Sites Act 1968. And then it proceeds with that wording that's already there.
Under enforcement.
Yes. Yeah. So we put that exception at the beginning. Then the next enforcement notice being the next one of the 22nd of April. Sorry, in addition, there's then an amendment to the plan to look like that. So plot 1 and plot 3 are marked.
Okay.
The next enforcement notice is the next one dated 22nd of April 22. That's the one with the irregular shape plan. I think you've called this enforcement notice 3.
Notice 3.
Again.
All except 1 and 3.
So 1 and 3. So we've done 1. That's.
Yeah, I'm saying this is the ops.
This is the ops only. Yes, yes, sir. Yes.
But it includes the access track to
yes.
plot 3.
So in paragraph 4, the notice will be amended to add the words at the outset. Sorry, at paragraph 5, that should be, apologies, at the outset, with the exception of the hard standing forming an access way to plot 3, coloured green on the attached plan. Yeah, I've made a few errors in it which I need to correct, so I'm going to start you to print it again in a minute. But if it just, this is a working draft, so if it would just help to have that, yeah. Yeah, so the idea there is to under enforce against the access track to plot 3. And then you'll see, so on the working draft, the next bit is paragraph 4 we're on now. In respect of enforcement notice 2, which is the 2020 enforcement notice, the parties invite the inspector to allow Levi Anderson's appeal against the enforcement notice on ground A, thereby granting for permission for the matters alleged, namely the laying of hardcore and hardstanding related to plot 3. That's all that need to be done on that, and you'll recall from that enforcement notice, it's the one with the much smaller shaped red line. Paragraph 5, the council would write a letter of comfort about a commercial vehicle, just to make sure that he's got some guarantee that a commercial vehicle on his site and on plot 1 won't involve any further enforcement, just in respect to the commercial vehicle. If, but only if, you are content with this invitation, Mr. Levi Anderson will withdraw his other appeals, the ones that are not affected by this, and Mrs. Wilkinson will withdraw her 2 appeals. Parties agree not to make any application for costs against any other party to the agreement. And then the council would invite you, sir, to dismiss all the other appeals. And then we've given a brief statement of reasons as to how we suggest this could properly be done in the exercise of your planning judgment and discretion.
The one thing I'm not very clear about is well, not clear about, but the number of other fees paid, for example, on enforcement notice 1.
I didn't hear that.
I said there's a number of other fees paid on enforcement notice 1.
We'll have to consider.
Yeah, that's it.
We've talked-
I'm assuming that I'd have to go to written representations on what I've got available and everything else, rather than
The only
simply
thing
just submit.
there was 2 things. One is you'll need to site visit.
Yeah.
The second, which obviously second is that tomorrow you by chance will have all of the council witnesses. I won't be offering any evidence. We'll have withdrawn 3 of our appeals.
Yep.
The only remaining is the one in relation to the access track and the ops on which the caravans are, and the council will be changes will allow the caravans and the access tracks under enforced on another one. So I'm not proposing to tax you with offering evidence on that. So, but you would have the council witnesses if you had questions. Ask questions of the 5 witnesses. It's going to be the case. I would turn up. I think would be here in case other matters have come. If you had any other questions overnight for the agreement. I mean, you could just do the site visit and revert to written reps on everything, but the other thing that they're here, you have the opportunity to ask.
Yeah, we support that suggestion, because you, sir, still have to deal with about 20 other appeals, so you'll want to satisfy yourself on all the others as well.
No, I thought at one stage you were asking me to dismiss those appeals.
The council invite you.
All right, okay.
So we would invite you then.
No involvement in the other appeals, so we're silent on that matter.
But the reasoning behind that we could explain in evidence tomorrow if need be.
We would just be in attendance in case something cropped up and you suddenly said,
Oh, actually, you can't do. Just proposed or something.
Well, I think, I haven't heard the reasons yet, but I mean, I think it's very unlikely that I could simply dismiss those appeals on what I've got, just as a matter of natural justice.
Significant speed.
Oh, yeah, no, it certainly will. Well, there'll be no
Done by tomorrow.
there'll be no cross-examination.
Indeed. Done tomorrow.
Essentially, it is effectively one-sided in the sense that, but it's not one-sided. It
would, in the circumstances, become effectively one-sided, but
yeah, I mean, I'd obviously be acting on the.
you'd effectively be running it inquisitorially, I would suggest, yeah.
Has he got Mr. Jarman turning up? You said he was
He's coming tomorrow.
he was on the road, yeah. You're not having a session with Mr. Jarman.
I will have the delight of listening to him say anything that you ask a question.
I can certainly ask him questions, because I'm not entirely sure where Mr. Jarman's position he's at the moment. But
I think it's not really. I think it would be probably more appropriate if you have the questions to ask them, rather than to revert to written reps. The reason is
I mean, I would
on the site.
Well, it would
probably not capable.
Yeah, it's
of engaging in a written representations process.
I'm not sure how this works. Yeah, I was going to say that it wouldn't be entirely written reps. It would be, in this new world that we live in, we kind of hybrid.
This is hybrid, yes.
Trying to think whether I think I'm trying to remember whether there's anything in the new levelling up and regeneration bill that was
actually had the final copy of it.
Yeah, I'm not changing procedure. I'm just adapting something as I go along. I think is yeah, because I think I can do what I like in an enforcement appeal. It's just if it's a lawful development certificate, I'd have a problem. Okay. Well, let's say I'll obviously have to do some thinking overnight, and
yeah, I should add. So you had suggested some minor changes as well, which of course we're content with. For example, you were saying revert to the former state of the land rather than to
yeah. I mean, I'll get the notices in order anyway. We'll resume tomorrow. I'll need, because I won't have anybody asking cross-examination questions to say I'll have to be inquisitive. I'll have to, yeah, I have to adapt my mindset to inquisitorial from adversarial, which I'm happy to do. Yes, so that's the basis of it, really. I will. So you've got your evidence in chief. I'm happy to take that as read. So I will ask some questions, but essentially I'll need to go through people's proofs beforehand to.
Yeah. So we'll just call each of the witnesses.
Yes,
and then hand to you. For...
Yeah. It's possible that we'd be done in the morning. And then the site visit, because there aren't any closing submissions from, well, I take it you're not going to, well, where are we with closing submissions?
Well, I could let my opening stand as a closing in the circumstances, and
I won't.
And then he.
Closing.
Yeah.
I will still have a live appeal circumstances. Thank you. Closing
Yeah.
So if you were to go away from here and going to back,
Yes, well, I'm assuming that the council has good reasons, planning reasons for arriving at the position that they've come to.
Yes, that's what we've tried to capture in the brief time available with the statement of reasons at the end, that just in summary terms.
Yeah.
To make that clear, this is based on a set of planning judgments as much as anything else.
So assuming that we do conclude tomorrow, I mean, you'll probably want to adapt your openings to make it at closing, given that.
Yeah.
It's more helpful to me that, because essentially this is an agreement between the parties, but your closing should be the council's position on the outstanding matters.
Yes.
Which won't necessarily be covered by this. The other thing is site visit. Do we need any kind of lead-in? Do we need any kind, I mean, there was some difficulty arranging the site visit for Friday, I understand. Can it go ahead tomorrow?
I don't see why not. Seems to be on the site more than 20 minutes. So at the time of raising concerns,
Yeah.
in a recent serious
Yeah,
incident,
okay.
which was spontaneous, at the time.
Okay, as long as everybody on site is aware that I'll be visiting the site tomorrow. I assume that you yourselves can let people know if they aren't aware through any other. Mr. Carruthers has obviously been speaking to the Stokeses and things. So. Yeah, great. So provisionally then we'll conclude tomorrow morning and site visit in the afternoon. Yeah. Okay. But I can't think of anything else to say because I'll have to think about this and think about it again. Okay, so that's the plan. Resume in the morning.
I think it's in use, isn't it, for a council meeting tomorrow? They're nothing in there.
No,
Yeah, so just tidy yourself up to one side in case there's an emergency meeting.
I don't need to take them back to carry on working on cross-examination and things like now.
I'm sure you think it's something to cross-examine.
I will be sat there.
Even though I might have to stop you.
Chomping at the bit, I will be. But listening to Mr. Jarman talk about needs, anything else to intervene on it will be an interesting.
We'll see how you pass the test. Yeah,
I can ask him some leading questions on your behalf. Well, Mr. Jarman's talking about surveys really and projection and so on. So yeah, okay. 10 o'clock then in the morning again. I'll adjourn until then and see you all then. Thank you.